Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How's it going, guys? How is it going? Here we go. Let me go ahead and grab one of these and pin that nonsense. Whoo! Woo-hoo-hoo! Oh. How you guys doing? Jeremy Griffin says, Flash turned me on to return YouTubeDislike.com. Highly recommended. Yeah, that's, if I'm not mistaken, that is the Chrome plugin that will allow you to see dislikes because YouTube doesn't want you to. For some reason, they don't want you to see dislikes. And again, they say that, it's for the creator, or something like that. That's not true. That's kind of garbage. They just lies. It's lies. Yeah, it's not for the creator because we can still see dislikes. We can still see dislikes in our creator studio on every single video. We can see the ratio of likes to dislikes. So if you dislike bomb a creator, the only thing that doesn't happen is it's not publicly displayed that they're getting dislike bombed. But I mean, that just makes people work harder, right? Because now they have to leave a comment that says, lol, you suck or whatever. And then the creator has to go in there, manually delete all the hurtful comments while they're news shopping or whatever. Everybody hates me. Like what I don't know what they're thinking. But that's what they're doing here. That's what they're doing. So yeah, tonight we've got kind of a variety. And if you're new to the nighttime shows, which some of you may be, new to the nighttime shows. We sometimes do these little variety shows with a bunch of different littler subjects. And then sometimes they're bigger subjects. Sometimes they're interviews. It really depends. But we do have a couple of returning characters here that are mentioned in the title. We have Russell Greer and Melinda Scott. Russell Greer and Melinda Scott are these beautiful individuals, full of idiocy, full of haughtiness as well, full of heightened and inflated sense of self. But that's who they are, and they have these ongoing lawsuits that we've been following. Melinda Scott has sued Kiwi Farms. Now, Russell Greer has also sued Kiwi Farms, but the lawsuit we're currently following, he is suing the production company behind America's Got Talent, because Russell Greer is a man with a disabled face. He has something called Mobius Syndrome, and he has sued America's Got Talent for not making what's called a reasonable accommodation under the Americans with Disabilities Act. Russell Greer pretty indisputably has a disability. That disability is the Mobius Syndrome, and it impairs with his ability to perform daily normal tasks. That's kind of how you define a disability. Does it get in the way of doing life that would otherwise be mundane or simple, like eating, for example, drinking through a straw, communicating, using a spoon, not stalking strippers? All of these things are easy for normal people to do, but sometimes you have a disability like Mobius syndrome where your lips can't close. So it's hard to communicate. It's hard to shove food into your mouth without it spilling all over like some sort of hideous garbage monster. It's hard to put a straw in your mouth and drink through it because you can't perform suction. And it's hard to not stalk strippers and celebrities because, you know, that's just the way it is. When your mouth doesn't close and your eyes are focused forward and they can't move side to side, so you have to move your whole head to look around, which, by the way, is a hard thing to do. I'd try it sometime. Try to make your eyes not track as you look around. You'll notice they lag a little bit, but his don't. And so when that happens, you have to stalk strippers. You have to take Bunny Ranch prostitutes to the Olive Garden rather than sleep with them and then get mad when they don't sleep with you. You have to sue Taylor Swift several times. You have to sue Ariana Grande. You have to sue Katy Perry. These are things you have to do when you get Mobius syndrome. It's really fortunate that it's so rare because otherwise these celebrities would be really overworked. Mm. But the reasonable accommodation. So the way that works is with the Americans with Disabilities Act, there's a requirement for what's called a reasonable accommodation for equal access of someone with a disability to the same opportunities that everybody else has. Handicap ramp, right? You're in a wheelchair and this public access place, a public accommodation only has stairs. Well, there's no way for someone in a wheelchair to easily navigate those stairs to get up there and participate, to have access to the public accommodation. So you put a ramp in, so then you can roll on up, and it's perfect. It's a really nice, simple way that is expensive, but relatively speaking, not super expensive. And since it's been a requirement for a long time, find a lot of buildings either have kind of on plane door thresholds, or they have a handicap ramp already built in. Any sort of modifications or improvements you do to the building, if it's a commercial building, are probably going to include those handicap accessibility features for wheelchairs, right? That makes sense. So you make a reasonable accommodation. It does have to be reasonable. So with America's Got Talent, Russell Greer, who doesn't communicate well because of his Mobius syndrome, he is a songwriter at heart and stomach and balls. He is a songwriter, and in this capacity, he has written a banger of a song in which he changes from stalking Taylor Swift to stalking Heidi Klum, because Russell Greer is naturally gravitationally drawn to the nearest female celebrity to his objective. So his objective is to win America's Got Talent. So what does he do? He writes a creeper song about Heidi Klum, about how Russell Greer looks like Heidi Klum. That's the whole idea. And again, his gravitational attraction towards the nearest female celebrity draws him right to Heidi Klum, who is the current MC for America's Got Talent. And he wants to be on the show. If you're not familiar, there's an audition process, then an in-person audition process in front of some celebrity judges, and then the people either stay or go. And then if they stay, they move on to do repeat appearances in front of these judges, get voted on by audience, and all this crazy stuff. So he writes the song, and because of COVID, they have auditions via Zoom. But he's not a singer. He's just a songwriter. He knows he can't sing. He's also a keyboard player. So he knows he can't sing. So he's going to play keys, and he hires a band, like $3,000 for this band to help him perform this song. And they're going to nail it. And they do their audition. They do their audition via Zoom, because everybody does their audition via Zoom. And a producer watches and goes, brilliant, brilliant. Please upload it and send us a link. And then that's cool. There you go. Thanks. We'll talk soon. You guys are great, though. You guys are great. Make sure you upload it. You're going to be good. Going to be great. And we'll see you. So that's what they do. And they're all like, yes, that producer said we were great. Said we were great. Of course, now we're going to win the show. That's definitely going to happen, because that guy on the Zoom call, he's like, yeah, we're amazing. We're perfect. Basically, Liberace eats the Beatles and then plays music, and it's, oh my gosh, can you even stop us? No, of course not. So that's That's where they go. Well, turns out they turn in their video and they turn in their audition, and America's Got Talent never calls back, right? Like that whore on Tinder. They just never call back. And you're like DMing. And you're like, come on, call back. And they don't do it. So Russell says that that America's Got Talent now owes him. They owe him a reasonable accommodation, and the reasonable accommodation is very reasonable. Automatic entrance to the live show next year. That's the reasonable accommodation because, of course, he's got a disabled face. So therefore, he should automatically be on TV for America to see, and they should be compelled to do that. They also, oh yeah, by the way, of course, they also have to pay for his band because since he has a paralyzed face and can't sing, therefore, he can't participate in a general talent show without hiring a band. And that should be on America's Got Talent too, because that makes sense. I mean, how reasonable is it that they would require him to perform alone or whatever, even though they don't? So he says they have to pay for his band and he automatically gets a spot next year. He's suing them for this in federal court. That's the lawsuit. So that's where this lawsuit is. That's where we left off. I hope that summary helps. I'll try and summarize these cases for the new people. I wanted to report that there's something really funny and crazy going on in this, but there's not. There's your traditional Russell Greer failure is what's in full swing right now. On the 23rd of November, which is the last update in this case, Russell Greer filed a motion for alternative service in Nevada, despite the fact that he's suing a major corporation and would presumably just have documents served at the company headquarters upon a competent party who's authorized to receive service. He is filed for an alternative means of service rather than do the simple and obvious thing. So with that, I thought I would pull up this request for alternative service to give you an update on where we are. It's only a couple pages long, and let's see what Russ's problem is with just simply serving the document in the normal way. I don't know. I haven't read it, but I don't think it'll take us long to get through. Oh yeah, while people are here, I do have to announce, first of all, thank you for joining me on the Kim Potter jury selection streams. Without you guys, I wouldn't be able to soldier through like 8 hours of Judge ASMR, Judge Fried Rice ASMR, or whatever racist, sexist thing you want to call the judge, that that judge. Because like I notice a lot of those comments in the chat. So I think this judge she seems fine. It's hard to watch, but she'd be kind of nice in a courtroom. But she's out there. Have I mentioned to the new people, by the way, the nighttime show is a little spicier. We get more jokes in here, and there's a little more profanity, a little more nudity. I mean, not really. We talk about more adult themed subjects at night because it seems a little more proper, right? If you're a kid watching at 11 o'clock, what the hell are you doing? Go play World of Warcraft or download porn or something. Don't be on here. Only if you're over 18. If you're under 18 watching this show, your parents should probably be put on a list. And if you don't like these subjects, and if you don't like the profanity, if you don't like the crude jokes, if you don't like the levity and comedy of tonight's show, that's fine. Go watch the day show, and I'm trying to keep those very segregated. Like one of the shows in the South, maybe 50 years ago. You know what I'm talking about? That kind of segregation where we've got some spicy and we got mild. All right. Mild and informative, spicy and entertaining. Hopefully both are entertaining. But yeah, if you're not into the more laid back late night radio style of show, you will not offend me by watching the normal one. So that being said, where were we? Thank you for helping me get through the Kim Potter trial. The jury selection is obscenely boring. I know, believe me, I'm there. But tomorrow we're going to start late. I forgot. Tomorrow is the other Thursday of every other Thursday for me. And that means I am teaching at our homeschool co-op tomorrow, which means I have to teach some high schoolers and junior high kids about the Constitution of the United States. And we're almost through Article 1. And the kids are like, oh, dear God, I hate Congress right now, right? Because it's super boring to read through Article 1. It's a long article, doesn't move very fast. They're creating an entire like legislative body that they created wasn't really around. I mean, there was some proto legislative bodies. I'm sure you could go back to Athens or whatever, but like they're coming from a monarchy and they're creating this legislature and they're building a lot of the components in it. That's why Article 1 is so long. They have to lay out all the powers that the legislature should have because they don't have a model for it. Article 2, much shorter. The executive power. Just if you want a quick Constitution lesson, this is a really easy one. Read the first line of Article 1, read the first line of Article 2, notice the similarities, notice the differences. Article 1 says the federal legislative power as laid out in this document or something like that shall be vested in a Congress comprised of a House of Representatives and a Senate. All right. So the legislative power as defined in this document or whatever variation of that line that it is. I don't remember the exact words. Very important. Article 2, line 1. The executive power shall be vested in a president. Whoa. Concise, beautiful. Similarities, legislative power, executive power shall be vested in a legislature, an executive. Difference, key difference, as defined in this document, no definition on executive power. Why? Executive power was already defined. Monarchies everywhere. Kings and queens for days. They don't really need to define an executive. They already know what an executive is. But in the legislature, they don't. So they have to create this congressional body. They have to create the Senate. They have to put those things together into what they want them to be. And so Article 1 is a whole lot longer than Article 2. There's your quick Constitution history lesson. Oh my goodness. You guys are going to make me drink too. Perfect. So anyway, we're about to move into Article 2, and then the Constitution picks up, gets more interesting, really gets interesting with the Bill of Rights, of course. And my goal was to try and be through the powers section of the Constitution by winter break. It didn't really happen. Part of the problem, I got COVID, and so did everybody else. So that put us back. But yeah, we'll be kicking through once we get through this first part. Anyway, because of that, live stream tomorrow starts a little late, probably around 10:15, maybe as early as 10:05. But I teach until 9:45 in the morning, and then I have to shoot home, get ready and start the show. Dude, you're a fucking nerd. Yeah, I know. I know I am. But that's the life, right? So anyway, teaching and I get to teach. My oldest kid has to suffer through my class this year. What a fool. He could have picked a different class and he didn't. Oh, what a mistake. So anyway, tomorrow's live stream will start a little bit later. I'm going to set it for 10:15, but it's fine. We can either watch it 1.5 speed or 1.25 speed, or I'll skip and catch up through the breaks. One of those things. All right. My COVID test is actually on Friday. My COVID test is Friday morning. So Friday morning will start a little late as well. Okay. This document is Russell Greer's request for alternative service, and he makes it an ex parte motion, which is fine. It doesn't really matter. It's just asking the court permission for alternative service. Plaintiff files this motion pursuant to Nevada Rules of Procedure 4.4 and moves for alternative service. This is in federal court. He should move for this alternative service under the Federal Rules of Civil Procedure, but okay. I think since he's pro se, they'll probably let it pass anyway. Facts. Plaintiff filed this pro se case on October 15th, 2021, alleging disability discrimination under Title III. On November 18th, the court granted the pauper status of plaintiff and determined he could state a claim. He had stated a claim for discrimination that survived the screening process. I don't know that this is actually true. Hold on. Survived the screening process. What screening process is he talking about? I'm guessing he's saying the order granting the motion, the screening process was the Informa pauperis proceeding. Informa pauperis is just where you file and the state pays your bills on your filing fees. They don't pay for a lawyer or anything. They pay your filing fees. I don't know what screening process he's saying, but I guess the screening process. They did not state that he has stated a claim for discrimination. This is actually incorrect. This is Russell Greer is he's a special one. They won't rule on if he's stated a claim for discrimination until the other party has an opportunity to respond. Because this is a legal conclusion. Oh, well, he stated the claim. Oh, well, did he? In the same order, document 10, the court ordered plaintiff to provide documents to the U.S. Marshal for service within 20 days. Okay. Nevada rule request for alternative service. Why don't you just give the documents to the U.S. Marshal? Nevada Rules of Civil Procedure 4.4 allows for alternative service. Greer is not seeking to have alternative service by email or mail or publication as found in the Nevada statute for alternative service. Rather, Greer would seek to have a private process server serve the registered agent of Fremantle instead of a marshal. There are a few reasons a private process server would be preferred in the alternative than a U.S. Marshal. Be in the alternative too. Private process server is cheaper. According to 28 Code of Federal Regulations, 0.1143, it costs the U.S. Marshal $65 per hour to serve summons, but you have Informa pauperis proceedings. The court's already paying for your service. In addition to 10 cents per page of document to be served, plus gas mileage, this altogether would be upwards of nearly $100. Greer's found a process service in Glensdale, California that will serve Fremantle registered agent and is allowed to accept service for just $30. Private service is quicker. As stated in Greer's complaint and motion for preliminary injunction, he is hoping for an injunction before April 2022. United States Marshal may be slower in serving summons due to possible caseload. The Marshal is not that slow. This is how you screw up something basic with idiocy. There's no reason to have anyone other than a U.S. Marshal when you're proceeding in Informa pauperis and they're paid for by you or by the state to do this. So the United States Marshal may be slower in serving summons due to possible caseload. Also, Marshal requires payments by check or cash. Private server accepts payment by card, so the service would be faster and would not need to wait for payment to process. Oh, yes, you're right. That devastatingly slow instant check processing and cash. I mean, what's he gonna do? How would he possibly how could he possibly wait until now or now or now for the payment to process? I mean, what would he do? Conclusion, plaintiff has shown why he should be allowed to have the summons served by private process server. Nope. Let's take a quick look at something. Hold on. This will be Russell Greer is going to be a pretty quick one. Nevada rules civil procedure. Yeah. I know it's really, really little. Here we go. Alternative service methods. So, lawyering tip. Everything you need to know about motion practice basically starts at the rules of civil procedure or criminal procedure. If you're going to file a motion, you got to support it by a rule or statute or whatever. So, Rule 4.4, alternative service methods. If a statute provides for service, summons and complaint may be served under the circumstances in the statute. All right. Court-ordered service. If a party demonstrates that the service methods provided by 4.2, 4.3, and 4.4a are impracticable, the court may, upon motion and without notice to the person being served, direct that service be accomplished through any alternative service method. So you first have to show that service is impracticable. Service to a registered agent of a major corporation is not impracticable. They're actually really easy. Major corporations don't get to hide. It's not like a person, right? Where you just never home. Sorry. Hard to serve. Nope. It's a building. And there's a person in the building, especially Fremantle, a massive media company that runs America's Got Talent. You just walk in you just have anybody, any third party walk in the door and do it. I believe maybe here you have to have a license. So service within Nevada, serving entities and associations. An entity that is formed under the laws of this state is registered to do business in this state or has appointed a registered agent in this state may be served by delivering a copy of the summons and complaint to the registered agent of the entity, any officer or director of a corporation, any partner of a general partnership, blah, 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 blah. You don't have to even have a special person. You could just deliver it. In Minnesota, you have to typically have someone else serve for you. Anybody can just deliver this. Now, he's probably mixing up the federal rules of service, but the federal rules of service typically allow for service within the jurisdiction. Let me check one more thing. Where did he say? Oh, wait, no. So here's even worse. He's filing for alternative service under the rules of Nevada in federal court for service that would be done in California. I can't tell you. There's no way to do this more incorrectly. I just realized that he said Glendale, California. You have to serve under the rules typically of the state in which you're serving. But he should be asking for alternative service under the federal rules. That's what he should be doing. Anyway, so this is where he is. The court may allow him to do this. There's no need to do this, though. You just deliver the papers to the marshal, proceeding in form of pauperis. I believe they pay your service fees, and then you're done. Instead, he's wasting the court's time. He wants this done fast, right? But he's wasting the court's time. The reason they tell you to do this through the U.S. Marshal, why a marshal is doing service for you, is because the court is going to pay itself. The federal court is going to pay the federal marshal for the service. That's why they're directing you to serve it through a federal marshal. You can hire privately a federal marshal for service, but if you have informa pauperis permissions, that's why they have you do it through the marshal. So he's wasting a bunch of time. Good job. Good job, Russ. You're saying you want to do it faster, and you've made it take longer. All right, so that's the update on Russ. There's really nothing going on. He made the request on the 23rd. He had to return this for service within 20 days. That was on November 18th. 20 days hits what, in 8 days? If the court denies his motion, he'll have to petition for an extension after that. Anyway, so there's the update on Russ. Not much to go with there, but I want to provide updates on these cases. They're in federal court. They're going to move at a glacial pace. Next, we have, yes, I want to stay logged in. Stop it. Don't ever log me out. Keep me logged in. You always want me logged in. Next, we have Melinda Scott versus Joshua Moon. Let me tell you a very, very short story. It's actually Melinda Scott versus Wise County Department of Social Services and Joshua Moon. Okay, stick with me, chat. This is, again, for the new people. Melinda Scott is a lady, sort of. She's a female person who lives in the mountains of West Virginia or something, or maybe it's just regular Western Virginia. I don't remember if it's actually West Virginia or regular Virginia. I guess I could look. Just regular Virginia. She lives in the mountains of Virginia, and she has some very interesting beliefs about Judaism. She claims to be a ethnic Jew. She's very white. I mean, she is the whitest person. I shouldn't say she's a Jew. She's an Israelite. She claims to be an Israelite, but from one of the lost tribes, right? The lost tribes of Israel, because not those ones, not the Levites or whatever who stuck around, who we think of as the modern Jew, like not that tribe or whatever, but one of the lost ones. And here's the cool thing about being a member of the lost tribe of Judah is that you can just make it up. Like, oh yeah, I'm super Semitic, right? It happens. I mean, they don't have any record of our tribe or any history around there, so I can just be whoever I want. Like, you can be a really white lady named Melinda Scott, who is definitely like the whitest, palest Caucasian ever, and you can just claim to be Tamar al-Yahbeth or whatever fucking pathetic fake name that she came up with. She just made it up. It's the best system. It's the best system to just make things up. And she goes by that name, except of course she doesn't go by that name. She goes by Melinda Scott. If she had even a semblance of actual attachment to this total ancestry that's definitely real, you guys, she would change her name to Tamar. But she doesn't change her name to Tamar because she doesn't believe in whatever patriarchal construct constitutes requesting a court for a name change, despite the fact that she will go to court literally constantly against everyone else. So, okay, Melinda Scott is you have to understand where we're coming from with this, why I'm emphasizing the fact that she lies about who she is. She lies about who she is because she lies about just about everything. It's part of her nature to be deceptive, to be a different person. I don't know if it's because her life is so horrifically terrible, but she must LARP as anything other than Melinda Scott. Melinda Scott is currently married. Maybe you see, when you don't actually adhere to the strictures of patriarchy, marriage to you means something different than it means to anybody else. So I don't know if she's legally married, but she is fake Jewish married, at least, if not legally married to a guy named Marshall. Now, Marshall is also like a weird fake Jewish convert. Marshall's great. I like this guy. I definitely want to buy him a Hasidic beer or whatever and have more discussions with Marshall at some point. Although I think he wants to harm me, so I don't know if this would work. But Marshall has read the secret texts about how America will be taken over, and he knows what country will actually do it. Spoiler alerts, it's Iran. And Iran will kill all the whites in America except for the lost tribes of Israel, like Tamar and Marshall. They'll be spared, even though whatever. But the reason that they'll be spared by the Iranians is because the Iranians want to spare the Jews to return them back to Jerusalem. No, I'm not kidding. This is where these people are. Okay. Marshall is her sort of husband. It's hard to tell because remember when Jesus went to the well, right? And he's like, "Woman, get me some water." And she's like, "Oh, okay. I guess you can take my water with my dirty slut hands or whatever that I'll give to you." And Jesus is like, "No, it's cool. It's cool, fam. It's in the middle of the day. It's like 1 p.m. in the desert, and that's why we're the only two people at the well, because we're the only two people who would be out in the beating sun. You have to come here at this time because you're such a prostitute that no one wants to be around you. You're dirty, you're contaminated." But I'm cool with that because I'm Jesus, right? And I hang out. And she's like, "Oh, this guy seems nice." And he's like, "Actually, though, just so you know, you've got 5 husbands, right? Because you can't stop getting that penis put in you, and you need to stop what you're doing. You got to marry the one you're with." All right. So Melinda bears some similarities, we'll say. Bears some similarities to the woman at the well in that she is somewhere between like 2 and infinity husbands. It's actually unclear to me. The rumor is 9. I don't know how many actual husbands she's had. And again, who even knows what kind of husband definition she uses because she gets to pick whatever made up one she has. But so Melinda, she's got several children. And one thing I want to wish is I wish only for the best for the children. I really do. They don't deserve whatever their crazy mom's machinations are producing. That's not their fault. And so, I don't talk about her kids. I don't want to know anything about her kids. I know that she has kids, and I wish them nothing but blessings and good fortune in their life. Melinda's antics draw a lot of attention to her and her family from various places, and we'll talk about that in a minute. But they also do from the community because Melinda seems crazy, right? And crazy people are like train wrecks that you can't stop staring at. So Melinda's had a lot of men in her life, in some semblance of permanent relationships, and has had a lot of children from those relationships, and is now with Marshall. They don't seem to do anything productive for society. Marshall might have a job. Melinda's job is to be a fake Hebrew scholar. No, I'm not making this up. I wish I were. And she actually has a page on one of those websites where you get to call yourself a scholar and write whatever you want. She has a page talking about how the Torah, first 5 books of the Bible, Genesis, Exodus, Leviticus, Numbers, Deuteronomy, right? Torah, how Torah is not patriarchal. Yes, you heard that. Torah is now a feminist book, apparently, according to Melinda. Every Torah scholar on earth is baffled by this conclusion, but that is where she is, and she can do it because she's basically on the angel fire of scholastic websites. So she has proclaimed herself a scholar of Judaism, of Hebrew, and has come to conclusions that literally no one else in ever has come close to reaching. Because when you just make up your entire life, you can make up whatever you want. Now, that's the background on Melinda. Melinda's antics attracted the attention of a place called Kiwi Farms, but I'm slightly exaggerating what actually attracted Kiwi Farms to Melinda. Melinda had a stalker. Remember, Melinda attracts a lot of attention from a lot of people. Melinda had a stalker. That stalker was actually posting about her on Kiwi Farms, posting very interesting and perhaps worrying things. So, Kiwi Farms, I think in specific, Joshua Moon, the site admin of Kiwi Farms and the owner of it, reached out to Melinda to say, "Hey, just so you know, there's a weirdo looking kind of into you and posting a lot on our forums about you. Just wanted to let you know because, might not be safe, right? That guy might be crazy." So Melinda responds in the rational way to this. She sues Kiwi Farms, right? Because that's what you do. If someone is like, you know, posting your information and stalker pictures and all this stuff of you on a website, and the website says, hey, by the way, you got a weirdo following you around. What you do is you sue the website. You don't do anything to the weirdo. You sue the website. That's what you got to do. So Melinda sues Kiwi Farms. Now, this is something like 6 or 7 lawsuits ago. She loses all of them. She keeps losing lawsuits. She can't stop losing lawsuits against Kiwi Farms. Now, Melinda is a brilliant legal scholar as well. I should have mentioned this earlier. She attended approximately some level of 1 semester of law school and then dropped out because she was probably smarter than all of the lawyers and everybody else. I don't know what her reason was, but she dropped out of the law school that she says she got into. I can't verify that she made it into any of this stuff, of course, because no one can verify anything in her life because she lies about so much that it's hard to tell what's true. But anyway, I'll accept her words as true that she went to law school for a little bit of time. And I believe it was about less than a semester. Maybe it was 1 semester, maybe it was a year, somewhere like that. But she did not in any way complete law school. So what's the most logical thing to do when you don't complete law school? Well, that's to determine that you actually know more than those dumb lawyers and you treat yourself as your own lawyer, because all good lawyers lawyer for themselves first. That's the first thing you learn in law school. They actually say, yeah, when you're out of law school, now you'll be your own lawyer, because that's what you should do. And then she's like, why do I have to go to law school to figure this lesson out? I'll lawyer for myself already. I don't need to spend all that money and time actually getting the legal education. I'm smarter than them anyway. So she goes and becomes her own lawyer, and she will tell you over and over that she understands the law and literally no one else does, despite repeated attempts to explain where she is wrong, using case law, using statutes, using direct citations, using her own failures, despite federal judges telling her where she went wrong, despite literally everybody saying, Melinda, here's where you're going wrong. She says, actually, though, I'm right and everybody else is wrong. All of the others are wrong, and she's only losing lawsuits due to patriarchy and misogyny. No, I'm not kidding. So Melinda has been filing lawsuit after lawsuit, and despite being the most brilliant legal scholar that exists, smarter than every lawyer to ever walk the earth, smarter than the federal judges, smarter than, well, really everybody, she can't seem to win any lawsuits. She can't seem to win any lawsuits. So she files like 6 against Kiwi Farms. None of them stick. However, her most recent lawsuit sticks in a weird way. Whew. Her most recent lawsuit is not directly brought against Kiwi Farms or Joshua Moon. Rather, it is brought against Wise County Social Services, which is Child and Protective Family Services in Virginia, specifically in Wise County, because someone allegedly called or contacted Wise County and they allegedly investigated her family for potential issues with children's safety. I don't know anything about that. I do not condone that behavior. The only time I condone contacting Child Protective Services is when you know that there is actual danger to real children presently in place. All right. That's the only time I will not call them under basically any circumstance. I have to be certain. Because I don't trust CPS. I've seen families torn apart by CPS. I've seen improper investigations into people who are not a danger to their children. I've seen people who are a danger to their children able to hold on and continue injuring those children under the watchful eye of CPS. I'm not a fan. But so I want to point out, I do not condone whatever activity that is, but allegedly someone did that. I don't know. And allegedly they investigated her. So she sues CPS. Not sure why she sues CPS. Doesn't really matter. In that lawsuit, she also sues Joshua Moon, owner of Kiwi Farms. And she serves Joshua Moon. Remember, we had the service issue with Russell. She serves Joshua Moon, but she doesn't do it properly. She serves him at an electronic mailbox in Florida, which is basically a Kinko's. And the service was affected by giving the process itself to a Kinko's employee who is supposed to then place it into an electronic mailbox in which it would be basically scanned and emailed to Joshua Moon, who resides outside of the country. Now, the problem with this is I'm not aware of a single state that accepts service of process to a Kinko's employee to be delivered by electronic mail to the actual person being served. That's not how service works, and that's how she did it. She told the court that she affected service, and then Joshua Moon, who allegedly never received the documents, defaulted. He did not respond to the lawsuit because, by his perspective, he was not served, and she was awarded a default judgment against him, even though all the claims against the government were dismissed. Joshua Moon then hired a lawyer, responded, and said, hey, I just received notice of this default. I was never served. And he got that judgment overturned. And that started the roller coaster we're on. The roller coaster we're on is that Joshua Moon ended up getting that case thrown out, dismissed by the court, as it properly should have been for failure to state a claim. Also, Section 230 immunity for anything said on the farms that could not be directly attributed to him. And lo and behold, there were no statements directly attributed to him that could be actionable under the law. So the case was properly dismissed. Now, Melinda then appealed and has since been filing motion after motion after motion. I will show you what the docket looks like, because that's an important part of this. And we're about caught up on this story. Here is the docket. It starts on July 8th of 2020. This has been going on for quite some time. And you'll notice we are now at item number 118. Now, the case was dismissed. Let's see. The case was dismissed. Here, February 16, 2021. Oh, wait. No, taking under advisement motion to dismiss. Here we go. August 30th, 2021. The motion to dismiss was filed. This was item number 61. This case ended on this day, August 30th. Everything after item number 62 is a post-judgment motion or related document. And now we have moved all the way to item number 118. Now, I'm not going to go through all of these documents. I'm not even going to go through most of the documents. The most recent activity is that they are currently, Joshua Moon and his attorney, Matthew Harden, are currently filing for attorney's fees. They're trying to get a judgment against Melinda Scott. In the process of that, Melinda files just tons and tons of documents, just tons and tons. In the process of that, they have supplemented their motion with a piece of evidence. That piece of evidence is a document from a separate case. That document involves bank statements and transactions. This is a public document. However, Melinda requested that that document be sealed because it contained some private information on it. The judge ordered that the document be sealed insofar as minor redactions to address information had to be included in the refiling. They did go ahead and refile it. That was here. That's this. The best part of this is that this judgment was entered by a magistrate. This judgment was entered by a magistrate. The reason that is important to this story is that Melinda Scott does not consent to magistrates. And she swears that if she doesn't consent to a magistrate, that a magistrate's order is invalid. Now, interestingly, she was okay with this magistrate's order and came up with a post facto reasoning for why this magistrate's order was okay. Obviously, it's okay because it was in her favor. But typically speaking, she says magistrate orders are invalid. In fact, she has spent dozens of pages arguing that magistrate orders are invalid on kiwi farms. So, this, though, we did talk about back when this happened. This has been sealed. I made the same sort of story about the comedy of the magistrate, but again, this is for the new people. Now, Joshua Moon filed a motion for reconsideration on the order of the motion to seal. Okay, preserved the objection by filing it and then said, hey, we object to this. We want it unsealed. I don't know why they had to do that, but this actually produced an interesting document. And that's what we're talking about right now. This document or this motion request was denied by the judge. So Joshua Moon's request to unseal the document has been denied by the senior judge, James P. Jones, the retired judge. I told Melinda, she didn't listen to me. She didn't believe me. She said I was stupid, but I told Melinda Judge Jones is still the judge. He's in a state of semi-retirement. See, he issued his order and then like the same day or the next day, he entered into a state of semi-retirement. Well, semi-retired judges still work. When you work a certain amount of time on the federal bench, you get to enter this state of semi-retirement, basically move to part-time, but you get to keep all your benefits. It's a good idea. So, Judge Jones is still there. And he has ruled on this objection. Let's take a look. The defendant, Joshua Moon, by counsel, has filed an objection to an order of the magistrate judge. I will deny the objection. Parties are engaged in briefing before the magistrate judge the defendant's motion for attorney's fees and costs. In response to a reply filed on behalf of the defendant on this issue, ECF number 99, the plaintiff filed a motion to seal a certain attachment 3 to the reply, ECF number 104. Defendant opposed the motion, number 105. Magistrate judge granted the motion to seal to the extent that she directed the defendant to file a copy of the attachment that redacts the address and any other personal identifiers of the plaintiff. The defendant subsequently complied with the magistrate's order by filing a redacted copy, preserving his right to object. Okay. A magistrate judge's ruling as to non-dispositive matters may be reversed only upon a finding that the order is clearly erroneous or contrary to law. While the magistrate judge did not issue a memorandum appealing detailing her reasons for the ruling, they are apparent on the record. While I understand the argument by the defendant that the attachment was a copy of a state court record, it was still within the magistrate judge's discretion to order the minor redactions under the circumstances of the case. Now's where we get interesting. The court entered judgment in this case 2.5 months ago, and the parties, plural, by the way, this is notice to both of them, continue to file numerous motions, replies, and surreplies, often containing unnecessary, virulent comments about the other side. Such pleadings needlessly distract the court from the consideration and determination of other litigants' rightful causes. I intend to consider the imposition of monetary sanctions in this case in the event of further such pleadings filed without good cause. It is ordered that Joshua Moon's objection pursuant to Federal Rule of Civil Procedure 72, an alternative motion for reconsideration, is denied. So this is a warning to the parties. Stop. You got to tell your kids sometime. Stop. Stop it. This order was here. Following that order, pro se motion for injunction, pro se response to motion for reconsideration, pro se motion for order to show cause by Melinda Scott, response in opposition to motion for preliminary injunction, and and for order to show cause filed by Josh Moon. Letter from Melinda Scott requesting issuance of a subpoena and order denying motion for preliminary injunction. Let's take a quick look at this motion for preliminary injunction. Good God. Yes, I said virulent, but it's virulent. My bad. Keep making fun of me, though, please. So she is asking for an injunction against defendant and third parties who frequent his website, kiwifarms.net. Let's take a peek at what her motion is for. She's asking the court to stop activity. Joshua Moon is the owner of kiwifarms.net. He has admitted he is the owner and records keeper of the site in a signed declaration before this court. Part of the mission of kiwifarms.net is to dox random targets by posting publicly for an international audience private information about their targets. This is not true. In order to dox targets, the Joshua Moon and his anonymous users post the residential addresses, places of employment. Neither of those are private information. Place of educational attendance, not private information. Make and model of vehicles, not private information. License plate information, not private information. Whereabouts of their minor children, which may, depending on the whereabouts, be private information. May. Also, they don't do this very often that I've ever seen, but maybe they do. Identifiers of the minor children, like county of residence, gender, names, ages, etc. This is not private information. Like, it's not. And residential information of minor children, they have absolutely no limit or boundaries for what they post. Joshua Moon, who is the creator and owner of kiwifarms.net, has created doxing a goal on his website with actual malice. Purpose of the doxing is to inflict harm and distress onto the targets. He uses other people who hide under anonymous profiles to do his dirty work. He is the puppet master. To post information and harass targets, it is also not unreasonable to assume that he also hides behind anonymous profiles to do the same. The users of kiwifarms.net have engaged in a pattern of cyberstalking of plaintiff Scott by way of doxing between March 13th, 2017 and the present date. Previously, plaintiff Scott asked the Western District Court of Virginia to seal her residential address when filing. Clerk of the district court scanned her request, which included a residential address, publicly onto pacer.gov. The document was then posted on Kiwi Farms. Whoops. You should have filed. If you were a lawyer, Melinda, or hired a lawyer, or if you were as smart, if you weren't so much smarter than a lawyer, what you would do is you would file the request, and you would, instead of writing your address on the request, write that it was confidential information. And then you would file a confidential information record along with that. And that confidential information record would be labeled confidential. It would be filed confidentially, and it would contain the confidential information that would be referenced by the other document, because that's how you do that. That's how you go ahead and file something confidentially, but still put it on notice with the court. It's amazing how you can manage these things. But you're smarter than a lawyer, so it's okay. Previously, plaintiff Scott asked the Western District of Virginia to seal the name of her minor children residential address listed on a protective order. Magistrate judge refused to seal it, and it was exposed publicly onto kiwifarms.net. That's because it's not sealable. Anonymous users of kiwifarms.net have posted unredacted copies of Exhibit 99.3 on Kiwi Farms. Plaintiff has attached exhibits demonstrating this. Anonymous users of kiwifarms.net have threatened to continue to use court documents to post personally identifying information onto Kiwi Farms and other websites. She's borrowing this phrase, personally identifying information, from HIPAA, right? Personally identifying information is typically in regards to healthcare. Personally identifying information, like a name, is not actually PII, but she knows this. Although court documents can be extracted from requests of the clerk of any court has the legal right to use discretion to deny a request that looks like it may be used for criminal purposes, such as cyber stalking. Defendant Moon's belief that clerks just pass out documents like candy is erroneous. First of all, I don't know that he has this belief. Second of all, public access to documents is basically, I guess they could articulate a cause to not provide access to a public document to a member of the public who pays the requisite fee. I guess they could do that. Plaintiff Scott is, I mean, they actually, I don't think they have the right to do that. They can, but that person could just petition for it. Plaintiff Scott is working on asking every clerk of every district court and circuit court to seal her records because prior to the existence of Kiwi Farm, she had no reason to do otherwise. However, this is a process that takes time. This is, you guys wonder if I sleep. You guys wonder if how like I keep up doing all this stuff. She is asking every clerk of every district court and every circuit court to seal her records. Between March 13th and the present date, users of Appellee Moon's website have engaged in cyberstalking behaviors, including but not limited to tracking the appellant's residential information, not cyberstalking, tracking the appellant's county of residence, not cyberstalking, tracking the appellant's whereabouts, not cyberstalking, so long as those whereabouts are in public places, sharing information from their findings of bullets A through C for an international audience by posting it on the website kiwifarms.net, not cyberstalking, sent the appellant harassing emails saying they intended to use her residential information to exploit and harm her. People who sent harassing emails might be engaging in online harassment. I don't know if that falls under the cyberstalking statute specifically, but that would be individuals. Joshua Moon is not doing this, as far as I know. Made death threats to the appellant. Doubtful. Highly doubtful. Made threats to do bodily injury to the appellant, made threats to do bodily injury to her children, and made threats to stalk her children through doxing and otherwise. Whether or not any of these things are true threats is hard for me to say because I don't know what they are. Before owning KiwiFarms.net, Joshua Moon previously helped create a website called 8chan, known for its extremist hate. 8chan was shut down by a host company called Cloudflare because of mass shootings orchestrated by its users. This is a lie. When that site was shut down, the gang of socially deviant criminals and stalkers of 8chan followed Joshua Moon over to Kiwi Farms. Kiwi Farms became the replacement for 8chan. Nope. It is the new place where his users are encouraged by Joshua Moon to engage in malicious behaviors against their victims. Nope. Joshua Moon helped develop 8chan and then later created 16chan. Next, he's going to do 32chan. And then it will be all of the chans. Both sites were for extremist hate groups that also promoted child pedophilia. The Daily Dot wrote that 4chan and 8chan boards existed to share sexualized images of minors and provocative poses. That's why 4chan and 8chan exist, mind you. And that some users of those boards post links to explicit child pornography hosted elsewhere. By the way, if this is true, it is more true of Twitter and Facebook than any other website on the planet. Twitter and Facebook are the largest single purveyors, dual purveyors, but individually the largest purveyors of child pornography on the entire planet. And it isn't even close. When 8chan was removed by Cloudflare, 16chan became one of its replacements. Kiwi Farms have also posted cartoon images of young children being sodomized on the site. Oh, she read the Shadman thread. That's from the Shadman thread. Because Shadman is the one who draws those. Because Shadman is a crazy degenerate and probably deserves to be electrocuted by Mike Pence. One can only be cautious then in wondering why Joshua Moon and his website users who are involved in these Chan sites are fixated. She can't prove anything other than Joshua Moon did some stuff for one of the Chans or two of the Chans. Are fixated on getting access to records relating to the plaintiff's minor children. No indication or record that this is actually happening. This court should not turn a blind eye to Joshua Moon's past history of promoting child pedophilia on websites which he helped create and also owned. This is a I'm not here to defend Joshua Moon in any way, but this is a big distortion of this story. But that being said, people can believe what they want. If you want to hear that story, go find it from somebody else, or go listen to Josh talk about it. I think he's talked about it on this show in past interviews. If you're interested, by the way, in learning more about Joshua Moon, I have interviewed him several times on the show. He is an interesting artifact of the internet, in that he believes in very, very strong protections for free speech. And he is one of the people actually out there creating a space for that free speech to exist. But again, I'm not here to defend him. You can, if you want to watch those interviews, go ahead. They're wildly interesting. We get into very, very interesting conversations. Plaintiff hereby motions the court to grant her motion for injunction against Joshua Moon to order Joshua Moon to remove the following from his website: kiwifarms.net and any subsets on kiwifarms.net, including kiwifarms.net archives and international sites, and any other site he may own in the future. All right. So she's asking the court to permanently enjoin, because any site he may own in the future, all of these things. Enjoin him from having these. Must remove these. Any and all court documents or documents otherwise posted on Kiwi Farms between March 13th, 2017 and the date of the order containing the plaintiff and her minor children's residence address. Plaintiff, so all of these things. Everything about Melinda Scott, basically. This is from the beginning of Melinda Scott saga to now. Everything about Melinda Scott must be removed from the board. Any and all text, comments, or images containing information from court documents or documents otherwise. Reminder, these are public documents. These are publicly accessible documents. Even the sealed document that she's talking about is still publicly accessible in the other court. They were all produced and procured presumptively legally, because literally anybody could just get them from the court. Either go to the court and have them printed off, or many of them have electronic access if you know what you're looking for and where you're looking for them. These are public documents that she's asking to have removed. Public documents that she filed with that public information on it, by the way. Any and all text, comments, or images containing information from court documents or documents otherwise. So court documents or any other documents about these things. An order preventing Joshua Moon from being permitted to post any of the information described in bullet 1 and 2 from the date of the order into all dates into the future. Further, Scott requests this court grant an injunction preventing any third party from posting online. If you want to find the hallmark of a true moron, you find the one that asks the court to ban everybody on the planet from doing an act. Because if the court grants this injunction, any third party is you, is me, is everybody. This right here, this document would be banned, but me showing it to you, apparently. This is where you find someone who is smarter than all lawyers turn into a drooling, dribbling mess of an idiot in a legal document. The court does not have jurisdiction over any of these people. The court at most has jurisdiction over Joshua Moon. Just him and Melinda. Just her. Nobody else. Nobody else. Any court documents. Nick, you are as funny as a Southerner. I am a Southerner. Any court documents, general document, text, image, or otherwise, anywhere online, kiwifarms.net or otherwise, anywhere. No one can post it anywhere on the planet. Any information that contains the plaintiff and her minor children's residential address. That means that this would include county websites, right? County records websites. Nope. They would be enjoined no matter where she moves, anywhere in the country. This judge would be ordering that any records, the plaintiff and her children's county of residence, Facebook, for example, or anywhere that she may post something, plaintiff's places of employment or business. So like, I don't know, LinkedIn, people searches, Spokio, Plaintiff's place of attendance at any graduate school. She says she went to graduate school. Who knows? This would enjoin the school, by the way, from doing that as well. Plaintiff's make, model, year of vehicles. Her children's. I ask for this. Her children's, whatever that even means. So anyway, this is what Melinda asked for. Now, obviously, she got this, of course. Obviously, she did go ahead and get this. Well, I mean, I guess I have to check. Let's see if she got it. She also sent a letter to the court requesting the IP address of one of the Kiwi Farms users. Order. The motion for injunction is denied and the clerk is directed not to issue the subpoena requested by plaintiff. Okay, so she didn't get it. She didn't win this one. Shucks. Man, I thought she had it. In this ended case, this judge is like, stop it. In which judgment was entered against the pro se plaintiff on August 30th, and the plaintiff's appeal from that judgment is pending in the Court of Appeals. The plaintiff has filed a motion for injunction and sought from the clerk a subpoena. These requests are immaterial to the merits of the case, which are before the Court of Appeals. So, they're denied. Nope. Okay. So there is Melinda. Whew. Sorry for the crash course in these internet legal weirdos. Sorry for the crash course there. I know it's a lot to take in. It's like, have you ever seen those essential oil diffusers, right? My wife has some of these things. It's like a pyramid. And then out the top, it spewts out this mist of whatever like horrific smelling essential oil you can get. It smells way too strong. It's like if you just ripped open your nostril and just right over the top of that and just breathed in a bunch of internet weirdery in the past hour. That's what just happened there. So if you're a little heady, just give it a minute. Now, in full disclosure, Marshall, Melinda's husband, I want to say he threatened to fight me. I'm not sure. I know he threatened to fight a lot of people, but I've heard he's a member of the Lollipop Guild. So, it doesn't really bother me, but he's also quote unquote, kind of a badass, something of a badass in the streets. He used to be known as Marshall Law. That was his street name. That was his street name when he was out there pounding ass in the streets. So anyway, that's done. That's done. All right, let me read a couple super chats that have come in, and then we will turn to the Supreme Court's abortion issue. Oh, no, wait. We have PokeMoron. That's right. This is not a long thing. This is another thing I will occasionally do on my channel. Sometimes I get into very, very interesting conversations on Twitter DMs where someone DMs me to tell me how horrible I am. And of course, the one thing I want more than anything is for that person to then talk as much as possible. And so I'm going to bring up the Twitter DMs of this Pokemon person. It's a Pokemon Twitter account. I don't know. You'll see. I mean, I'm not going to hide who the account is. So we'll do that. In just a minute. Okay. Gunblade Knight says, Your Honor, I would like to turn the court's attention to the fact that the deceased is named Chad. Therefore, the defendant, Mr. Kareth, must be a virgin. As you can see in this meme, the prosecution rests. I was gonna do the virgin shooter versus the Chad deceased meme. I was gonna make one, but I haven't gotten around to it. CBDX.com says, here again to say we're happy you're live, and once again remind everyone that using the code KNOWS will get you 20% off of our products, which get you high and are legal. CBDX.com says, and just to clear it up preemptively, despite our name, we sell Delta 8 THC, not CBDX. So that's from CBDX.com. You can check that out. Tiago Toshimi says, Russell Greer and Melinda Scott in the same video. Are we in Christmas yet? It's just a crash course. There wasn't much going on with them, but I wanted to catch everybody up because I've been hitting these trials and I have not forgotten about the subjects that we were talking about before the trials. Comic Nut 64 says, this is totally off topic, but is there any update on the Sophie Long case? It's pending appeal right now. I don't know the status. I'm trying to get some more information on it. I don't know why I asked. Just something about it makes my guts turn. It should. It's a tough case. As far as I know, Michael Long is still on the lam. Is he on a lam? He's not in custody, and Sophie is still in his care, as far as I know. Wonder if Nick will do an impression of Richards explaining 4chan to a judge. Your Honor, there's a internet website called 4chan chain. I don't. It's got slashes. It's kind of, Your Honor, like a message board, if you imagine maybe like cork in a rectangle and pins, like in your office maybe, or by the water cooler. And people can go post with numbers or something. Some numbers are given to them in a flag, and they post it on the board, like with a pin, but on the internet though. And something about mixing chemicals and chemical burns, other stuff with these little green text where the stories are in green. I don't really understand but that's 4chan, Your Honor. I rest my case. Okay, there you go. There's that. Sorry. RPG or 90 says, did you see the Tucson cop who shot a guy in a motorized wheelchair who supposedly had a knife? Also may be fake, but supposedly Kyle is going to sue LeBron. That looks fake to me. I cannot find any documentation in the federal court records for that. And they say, but the tip that it might be fake is that on the website that I saw it on is the Potatonator or something like that. And it said that they would be filing suit in every federal district court just to be sure. So I'm pretty sure that's a fake. But yes, I saw the Tucson cop. We watched that at the end of the hearings today. Just looks really awful. Even if the guy had a knife, I don't see him as being a threat. He's shot from behind. He does not seem to be in imminent danger to anybody, not even close. And the allegations are that he wanted to do a suicide by cop. It's like, so you obliged? That's not how that's supposed to work. And he was driving away from the cops. So I don't know. It didn't make sense to me. I'm waiting for more details, but he's already been fired and his police department has thrown him under the bus. Also, the cop was off duty working security for Walmart. I would not recommend that action. Does not seem like a legally sound move. Sealy Star says, loving the spice. Great coverage of the taser trial. Hope this helps feed that flock of yours. Oh, thank you. Thank you, Sealy Star. It will. I have a prime rib roast that I'm just dying to cook. But I need I don't really have 4 hours of cooking time right now. This is my issue. Because I want to smoke it, right? Smoke it to medium rare. Takes about 40 minutes a pound, 4.5 pounds. A little less than 4 hours, but with prep and everything, about 4 hours. And I don't have that just yet. I might get it prepped tonight, throw it in the fridge, take it out on a break, and throw it on the smoker tomorrow before my show ends, so it's ready by dinner time. I might do that. I'm not doing a prime rib in a crock pot or an Instant Pot. No, that you do those for for like chuck roast, really good stuff like that, but not this. This is a prime rib. All right. Do it right now. I don't have 4 hours right now. Sous vide. I thought about doing sous vide. I could just throw it in, for like 16 hours or something. But am I the cook of the family? Yes. Yes. I've been cooking ever since I was about 12. Okay. Let's look at this Pokemon guy. We have to do this in a very careful way because I don't want to have anyone else's information visible. All right. So how this works is typically, if you're in Los Angeles, by the way, this is to my anime people out there, well, and others, and longtime channel watchers. Vic Mignogna will be at LA Comic-Con this weekend. If you're in Los Angeles, if you like Comic Cons, he's actually going to be there. He's not a guest of the convention. He's a guest of one of the booths at the convention. So there's a booth there that will be hosting Vic Mignogna. He'll be doing signings and fan meetings and stuff like that at LA Comic-Con. If you like Vic, if you like that stuff, go there. Go hang out there. Vic is out there still getting work. Guys, I would love to talk about what's going on with him more fully, but there's some things that are not quite public yet, but it's cool stuff in the works. From the rumor mill, I guess it's a rumor mill at this point, but it's cool stuff from the rumor mill, and I wish nothing but success and the best for him because I've gotten to know him pretty well over the past 2 years, and he's he's a good dude. I don't know. Fans love him. He's like one of the best live appearance people I've ever seen deal with fans. He's as I start to meet people and go out and do conventions and stuff like that and see people at these shows, I try to model that level of interactivity and commitment to actually just hanging out with people, being with them and treating them with dignity and respect as much as possible. So it's kind of a learning process. He's really good at it though. Justin White says, greetings from Chaska. They make hot dish flavored bourbon. Oh, why do they? I have no idea. If you don't know, Vic Mignogna is an anime voice actor. He was the voice of the main character in Full Metal Alchemist. That's one of his biggest roles where people know him from. Hi, I'm Edward Ulrich. And maybe we all have a heart of full metal. Or whatever. That's Vic Mignogna. He's in several other, he has like 300 anime credits. He's Broly from the Dragon Ball Z franchise and the Dragon Ball Super movie, Broly. And finally, the other thing that he is very well known for in a completely different space is he played Captain Kirk in a fan production called Star Trek Continues. If you're a big Star Trek nerd, Star Trek Continues was like a 9 episode series. It's available completely for free on YouTube. And they've actually recreated the original Star Trek set, and it is designed to bridge the time between the ending of the Star Trek original series and the first Star Trek movie, because it kind of cuts off at the end of the series, and then suddenly you got this movie which came out, 20 years later, something like that. And so that series was them recreating it. He plays Kirk. He was instrumental in writing the episodes. They have lots of, go check it out. If you like Star Trek, the original series, it's made with about as much love as possible. And you can visit the studio, which is in Kingsland, Georgia, which is actually pretty cool. You can go and go, sit on the holodeck or whatever. If you're with me and Lady Rackets, you can climb up the tube that they say don't climb in. Oh, it was 11 episodes, not 9. So yeah, you can check it out. That being said, all right, here we go. This is PKM Cards on Twitter. So I can tell you some interesting things about this. I don't think this person and I were going to agree, because sports card account, PKM Cards. I thought it was Pokemon, but maybe it's just PKM Cards. So maybe it's not Pokemon. I don't know. But they do have soccer, the hobby PC, whatever that means, U.S. women's national team. Uh-oh. I've got bad news for you. So not Pokemon. I'll have to change it. So PKM Cards. Okay. I'll just change it to PKMoron. So they tweet me or DM me out of the blue. It says, "You aren't a media site. You're just another right-wing human who wants to let someone off who committed murder in front of your eyes watching the video. Anyone who would ever think of leaning towards innocent doesn't deserve a voice in any topic like this ever. It's legitimately cold-blooded murder, and you can literally watch it. The only possible way you don't think it is if you want gun right to stay lenient. So sad and sick." This is, of course, in response to my tweet that says I'm leaning towards justified for Kyle Kareth. Now, notice I didn't ever say that Kyle Kareth was innocent. I said justified. But that being said, I love these are my favorite DMs to get because of what's happening right now. I get to share this with you. I said, or perhaps there's a set of laws in Texas that are I think this is supposed to be make, but I was on my phone. This illegally justified shoot, even if it is morally disappointing. Gun rights to stay lenient. Raffle. Guns are the least lenient right that we have. It's embarrassing. I'm sorry you don't like my legal analysis. Go do your own. Look at me. Look, I'm nice. Okay? You don't do legal analysis, smiley face. Is this Ron? You just literally admitted you don't by explaining your bias. It's like, wait, okay. It's why you are so enthralled and enamored with the Potter trial. There's got to be, hundreds of similar cases happening right now? No, there are not hundreds of similar cases happening right now. And it's one of the only cases I know of that's televised. There are other cases being televised. Law and Crime, just so you guys know, Law and Crime basically always has a trial going. It just, most of them I've never heard of. So, if there's not public interest in the trial, I don't know if I should bother covering it. But, law and because I like that people can come to the case that we're looking at having drawn some conclusions about what they think, because then they can see how it plays out. That's the spice, right? So yeah, but hundreds of similar cases happening right now to Kim Potter. So there's You think there's hundreds of cases where a lady cop who was on the bench or on a desk job for 25 years, brought into the field for a year due to defunding issues, accidentally pulls a taser and shoots a fleeing misdemeanor warrant suspect or gross misdemeanor warrant suspect. And it appears to be completely a mistake, a complete accident. The question is whether or not she's criminally liable for that accident. Does anybody think Kim Potter was like, oh, I'm going to shoot this N-word? Does anybody actually cognitively think, even like the most pro BLM people, I don't think that Kim Potter set out to shoot Dante Wright. And she's like, oh, this mother, pretty sure he stole my bike. Blam! Of course not. Pretty much all the indications in Dante Wright's shooting is that Kim Potter made a grave mistake. Grave mistake. But I mean, someone says yes, they do. Maybe they're out there. I haven't actually seen them, which tells me that it's probably a minority. But and by minority, you know what I mean? A minority of people, not a minority. Stop it, chat. Naughty. No. You're not allowed to notice. Okay. All right. Back to seriousness. Back to this serious Twitter conversation. I said, you think lawyers aren't biased? This is another one of my favorite things. Oh, but I make a critical error. See if you guys have caught the error yet. It's already here. The error has already manifested in my conversation, but I make a critical error early on in this conversation. And I'll realize it later. But this is one of my favorite things about people who talk about lawyers. Like, your coverage is biased. Well, yeah. I'm trained to be an advocate for a client, advocate for an issue, advocate for constitutional rights, those types of things. But yeah, so bias is not foreign to lawyers. In fact, it's baked into us. We have to choose consciously sometimes our biases. Because, for example, when I'm representing my last criminal case, right? My last criminal case is someone who was convicted of embezzling. Basically, it's a long and short, simple explanation: embezzling hundreds of thousands of dollars over a period of 5 or 6 years. And they pled guilty to it. They admitted to the criminal act. So I can say that they were doing that. It's an open court. They're now in prison for that act. And I have to accept the actions of that person, even though they disagree with all of my moral fiber, with all of my personal beliefs about money. And I have to represent that person as zealously as possible with their interests. So I have to consciously choose a bias towards someone who stole money from someone else, which I don't steal money from anybody. I don't think I know when I was a kid, I tried to steal something and got in a lot of trouble really fast. So I'm not aware of anything I've stolen. I mean, I don't even steal like music or movies. I don't pirate anything. I don't do any of that shit. It's ingrained into me. Pay for what you want. So I don't do that. But I have to go against that and choose a bias that is opposed to mine. But anyway, I say, you think lawyers aren't biased? Duper Da says, you have too much faith in socialists, Nick. Read Any Faith at All. Of course they think that. Tell yourself a lie enough and you'll believe anything. Oh, speaking of bias, I am biased towards this. Look what I got in the mail. Gonna install this bad boy when I maybe over the weekend. 4 terabyte M.2 drive. PCI Express 4. 4th generation PCI Express. Ooh. Yeah. Kurt, that's a lot. I mean, kind of, but my my NAS server is filling up. I'm gonna have to upgrade my NAS server at some point, which is I don't know how to do that. Like, I mean, I know how to do that consciously. I might just build like a big server rack because I have 15 terabytes in my NAS server, and that it just keeps filling up, keeps filling up. All right, so here we go. Back to this. Yes, a sweeping generalization to make your inability to objectively look at the law become a moot point. More lovely stuff. I don't know what that even means, but I just asked if they think lawyers aren't biased. Though they keep. Anyway, you're an idiot. We're literally trained to be biased. That makes it all better. More generalizations. Nice man. He called me a nice man here because there's no comma. Robert Stratton, I'm pretty sure they are in RAID 5 right now. It's like the hybrid RAID system where it's got failure safety or whatever built into it. I said, you were saying about generalizations, genius? And I sent back, look at it. Remember how he started. Right-wing human. Anyone who would ever doesn't deserve a voice in any topic ever. The only possible way, if you want gun rights to stay lenient, they're accusing me of generalizing. Like, wait a minute. So your entire opening is literally generalizations. You've proven every single one to be true. You were right-wing. You only want this to be dismissed because of your personal gun rights. I didn't even say I don't even want Kyle's case dismissed. I don't care what happens to Kyle Kareth. I just think it will be because it's Texas, because I've read the law, because I firmly disagree with Andrew Branca's position that 1/2 second after someone hits you, the encounter is automatically over until they intentionally re-engage. And that there's no reasonable person on earth who could determine that they're still under threat 1/2 second after they were just assaulted, after the person threatened to murder them. I mean, I just disagree with that analysis. I get where he's coming from, but I don't know if he's even going to get indicted by the grand jury. And if he does, I don't think he's going to get convicted. I was watching Viva Fry and Robert Barnes had Andrew Branca on Sidebar today. Great show. Fantastic show. You should check it out for sure. But there again, I urge you, if you're interested in that case, to go listen to how Branca has framed the issue, because how you frame the issue is really important to the conclusions people draw from it. And they kind of talk about that in reference to the jury. And if you pay careful attention, Andrew Branca even kind of comes close to admitting that within the black letter of the law in Texas, that it might be justified, but under a moral argument before a jury, it might not. And that, to me, was extremely telling. I think he's softening on his position a little bit. So I'm going to keep beating on it. I'm going to keep pounding the drums. I'm going to keep pounding the drums on that. Craig Baker, very interesting point. He says, Branca convinced me to his position. Moment to moment, things change. Correct. How long is a moment? How long is a moment? That's my question for you. What is a moment? Because I'll tell you what the law says a moment is. The law says that the moment is determined by the reasonable perception of the defendant and is presumed to be reasonable in the circumstance. And that is the key to how Texas law plays out in this case. Now, I'm happy to be wrong. If Kyle goes to prison forever, good. Good. I won't shed a tear. I don't care anything about him. Don't know the guy. Have no vested interest in his guilt or innocence. I'm just looking at the law in Texas and I say, don't think he's going to be convicted. So with that, you don't deserve a say. You don't. This is, if I can make a generalization, and I'm making it based on the fact this person keeps calling me right wing. This is how leftists operate. You don't deserve a say. That is the difference between. Yeah, Tony Alto, I want to address that in a second too. That is the difference between me. I don't know. I'm not going to speak on behalf of the right. Me and the left is that leftists, and I mean real leftists, not Democrats, not even liberals. I mean leftists do not want you to have a say. I will let anyone have a say. I want everyone to have a say. I want everyone to have more say than they already have. This person doesn't even want me to talk. And that's the interesting part of this. Why don't you want me to have a say? Why do you think I shouldn't be allowed to talk? Is it because you're scared? As you are emotionally compromised to staying objective. Now, Tony Alto, I think, is the person who said it. And civil law says a moment is exactly 90 seconds. Yes. Well, that's the moment in the Kim Potter judge's court. Where was that? Where was that? Scheisse. I lost the, oh, you're here. Where are we? I so disagree. A couple seconds is not enough time. We could clearly see that guy making a move towards Kyle before he shoots. Oh yeah. So this is my other problem with Branca's argument, which I think is messy. Is he says, Branca, according to him, if that guy makes any move, he even said today, I think, if he leans forward, then Kyle can shoot. So if he leans forward, if he steps forward, if he makes any forward motion at all, then Kyle is 100% justified in shooting. If you're going to tell me, right, that in 0.6 of a second, the moment changes sufficiently to say the encounter is over, it is done. You are not justified in shooting. It's actually less than 0.6 of a second, but I'm going to stick with 0.6 of a second. So in 0.6 of a second, you say that encounter is definitively over. But any movement forward, including a lean forward, means you are under threat of imminent death or serious bodily injury in the same encounter, the same fact set, but all we have is going from this to this, and it's a justified shoot, then that encounter is not over. If this to this is not over, then this was never over to begin with. That's my counter argument to that. I do not see how you can reasonably say, oh, the entire encounter is over unless he does this. He even said if he stepped towards the door, and this is absolutely incorrect in my opinion. He said if he steps towards the door, Kyle would be justified in shooting. So if he turns around and retreats from Kyle towards the house, then he's justified in shooting because then he may go commit the burglary that he says is over also. I don't think that's a good argument. First of all, I think if he turns his back to Kyle and Kyle shoots him, there's no way is he justified there. I really think I really personally disagree with Andrew's analysis. Again, you should listen to it. He's very smart. This is his field of expertise, and he's great. I keep talking about this Kyle case. I don't really want to, but I was listening to this thing. I was listening to them discuss it today, and I was thinking, I just don't agree. I do not agree with you. I don't. But I'm not telling you that my position is right. I'm just telling you my position and where I think weaknesses in his arguments are. And if he can address those weaknesses, great. Again, he's the expert. I'm just a jackass with a YouTube channel and a law degree. So that's my take on it. But definitely listen to his. But if you're listening to him on Viva and Barnes, those are some points of interest. I didn't get to watch all of it. Those are some points of interest that I caught in the. I watched about 20 minutes, and I think those are weaknesses in his analysis personally. And this is healthy discussion, right? I don't mean that with any sort of malice or anything negative towards him. If that is able to help him refine his argument, even for his position, then that's a good. That's a good. All right, back to this. Sorry. It's a little discombobulated up here at night. It's as simple as you would not be fit to be on a jury. You don't want me on a jury. Nobody wants me on a jury. Please give me a jury summons. I think it'd be voir dire would be hilarious. I would love to be voir dired for a jury. I know I won't get on it, but I would love to be voir dired for one. That would be fun. And if they did put me on the jury, it'd be even more fun. I had zero background. Watch the video. Look at this. Look at his justification. I had zero background, watched the video, read up on some local lawyers talking about gun and custody law, and made my decision. That's the basis. I read other people's decisions. Okay, cool. I love that you don't realize your own hypocrisy. I have no hypocrisy. I did my full due diligence, and you did not. They don't know. This is a secret. This is the error I didn't realize. They have no idea that I'm a lawyer. They think I'm just a Twitter. Literally, they think I'm a Twitter account, and they think they're unfamiliar with anything else that I do. Now they'd still think I'm right wing if they went and looked at my channel. That's fine. But I'm a bad right winger, by the way. My best friend's a big black guy. I'm terrible. I'm a terrible advocate for the far right. Although he's probably more racist than I've ever been. So that's good. But I realize at this point he has no idea that I'm a lawyer, and I have spent more hours on this case than this person could even imagine spending on anything. It says, if that was even and when I say I'd be a bad right winger, I mean in the way that this guy categorizes right wingers, right? I do not think the right wingers are racist. I mean, some of them are. Some of the left are racist. There's racists everywhere. That's fine. Racism is constitutionally protected thought, and you know, whatever. If that's your thing, cool, go for it. I'm not going to stop you. I don't care. But what I mean to say is in the way that this person is clearly defining right wing. If there was even a sliver of doubt within local law that this man should still be walking free, I wouldn't be within miles of your post. Well, then you don't understand the law. I mean, frankly, again, even if you talk to anybody who's an expert on this, they're going to be, Branca says, if there is any change in fact, the minorest change in fact changes his whole analysis. And just about anything. Again, he's even said, if he can show that he was taking a step forward, that he was even leaning forward, he switches immediately. Due diligence, listen to some random lawyer and made a decision based on their analysis. Sure, homie. Those are the most typical responses you'd ever see in a psych book of someone who hasn't done research trying to tell someone who has that they haven't. You're right. He's right. I haven't done any research on Kyle Gareth and Chad Reed. Done zero research. I've dedicated 10 public hours to at least to discussing this. I've talked to and argued with one of the foremost experts in the nation on this subject, very specifically. Oh. Uh, so anyway, somehow it's now you can't believe I did research. I didn't even say you didn't do research, just not due diligence. I'm now a liar to make me wrong. Didn't call you a liar. Lovely mental gymnastics going on. I'm going off what you said, pal. then then he cites this. Have you guys seen this? Amy Swearer. He calls her a local lawyer. She's a legal fellow at Heritage. Hold on. By the way, Amy Swearer's analysis is severely lacking on this case, in my opinion. This is Amy Swearer, a legal fellow, Mies Center for Legal and Judicial Studies. Okay. That's it? That's her entire resume, huh? Amy Swears she's been at the Heritage Foundation for 4 years, 6 months as a legal fellow, a senior legal policy analyst, a legal policy analyst, and a visiting legal fellow. She was a Koch associate for the Koch Foundation and a law clerk in Lancaster County, New England's public defender's office. She graduated in 2017 from the University of Nebraska College of Law. That's after me. So I've been a lawyer longer than her. Been in private practice. She has not. She was a clerk at the public defender's office. I mean, I'm not putting my credentials up against many people, but as far as expertise goes on self-defense laws, I mean, I'll tangle with this chica. I don't see anything in her resume that indicates to me at all that she's particularly qualified above anybody else with a law degree to talk about this issue, which includes me, right? I'm not, and believe me, I don't criticize people's credentials. I really don't. I went to a shit law school. I basically trash tier grades in undergrad because I was a writing major. Who even fucking cares about grades? You guys went to class? I was doing cheerleading and fight clubs with the cheerleader that I would marry. It was great. College was fun. I would do college again, especially if I could bring my wife back to college. Wow, what a blast we had. I'm not a credential snob in any way, but I'm looking for some particular expertise which would give her any more weight to her analysis. I've read her analysis. Not great. Daniel Erler said, no, not a cheerleader fight club, although some of the cheerleaders came to fight club. It was cheerleading and then also a fight club. It was great. Very fun. All right. So anyway, there's someone that defended Rittenhouse as if this somehow qualifies like her opinion in some better way. I don't know what that means. Eddie Oliver says, Nick, what is getting lost here is under Texas law. If I punch you on your porch, that is burglary, not assault. I've covered this. I've had stupid friends do it and they were charged with felony burglary. I punch you at the store. That's battery. Yep. Exactly. I've actually had two friends to do almost exactly what Chad Reed did, chest bump, nipple touch, and both are facing felony burglary charges. Thank you. And that opens the door to deadly force to protect property. Yep. 100% agree. Bronca says you can't sell a Texas jury that's burglary. I say bullshit. Of course you can. It is burglary. It's in the statute. It's the literal statute. It's not the black letter of the law. It is the law. It's not only the law, it's the law that Texans have understood and lived under forever. Find a Texan. Most Texans, I shouldn't say most, many Texans believe that you can shoot someone merely for trespassing on their lawn as long as you give them notice. I'm not even kidding. Many Texans still believe that if someone is just merely on your property without permission, you've got a gun, you give them notice that you can shoot them. If this were happening in really, and the reason that Texas is so strong on property law is because of who founded Texas. Who founded Texas? People fleeing from debt who wanted big ranches, lots of land, and privacy. Why do you think they let you protect property? I got a big ranch with a lot of cattle. You touch my cattle, I'll fucking kill you. It's still good law in Texas. Don't do this because it'll be bad law pretty quick if you do it, but it's still good law in Texas. If someone steals your purse or wallet, to chase them down. If you can't catch them, to shoot them as they're running away. The extent of the encounter in Texas for chasing down a fleeing thief is the range of your bullet. And I'm not kidding. So Bronco's making a big deal about 10 feet. Okay. Texas law will give you 500 yards if you got a rifle. It's crazy. It's way different than any other state. Any other state that I'm aware of. Texas is unique in this way. So yes, you have to bring up Texas law because Texas juries live under that law and they have an understanding about property rights that is different than the entire country. And that's why I love Texas. I love that state. Also why I don't steal. Born there. Don't steal stuff. Renee Villarreal says, it's what my family believes. And you know what? It might fly in the more rural areas of Texas, might still fly. Now, you're not going to get away with that in Austin or San Antonio, Dallas, Fort Worth maybe, but not Dallas, not in Metro Houston. You shoot somebody who's just merely on your property. Yeah, you're going to go to prison. But you're talking about like, you're talking about West Texas where Lubbock is. You're talking about Northeast Texas near Jacksonville or Noonday? You go to Noonday. You go to Noonday and you stay on someone's land after they tell you to leave. Good luck. You'll need it. No, thank you. I'm not touching shit that isn't mine in Noonday. Okay. Amarillo is one of the places I felt the most unsafe in my entire life was in Amarillo, Texas. Enter the QB says, if a Vic decision comes back positive, pretend to be super depressed during the video, including the sad face thumbnail, so that Kick Vic gets their kicks, then unleash the salt mines as you read the good news. I'll think about it. Okay, back to this. There's someone that defended Rittenhouse again, as if the Heritage, first of all, the Heritage Foundation is politically biased and politically motivated. They're the Heritage Foundation. They're an advocacy group. I mean, I know they say they're just a bunch of experts, but they have a specific policy advocacy division. Like that's their whole purpose is to advocate a set of heritage policies. That's what they want. I don't know how that impacts their analysis here. I don't know if it does, but you have to understand that Heritage Foundation, Amy Swearer, is motivated, is biased. Of course she is. Her defending Rittenhouse has nothing to do with her analysis in Chad Reed versus Kyle Kareth. So you should maybe watch my several-hour breakdown of the case supported by statutes, case law, and video. I read the Twitter thread. It misses a lot. Rittenhouse had legal recourse. It made sense by the law what happened in his case. Oh, did it? Do you agree with the Rittenhouse decision then, do you? I'm sure you do. If you can show me that one time you've genuinely sought out breakdowns in law to prove the use of gun force was wrong, then I'll go away. Michael Drejka. Right there. Took me no time. Try not to be a fucking moron. Michael Drejka covered it on this channel, talked about it just the other day. Drejka's not justified. He failed the elements of justification. Here's a generalization. Why is it a prerequisite to be a beyond angry human if you're right wing? Wait, what? Like you are just one angry person. Now this is almost an hour after I replied. And I'm like, angry? I'm a jovial motherfucker. You mistake condescension for anger. No, I didn't. I don't at all. You wouldn't be cussing otherwise, or even responding to me if I didn't strike a major chord. This is now I'm like, oh, this guy doesn't know who I am. This is how I make money. I make money laughing at you. You clearly are unfamiliar with what I do. That's cute. Profanity isn't a sign of anger. That's a generalization. Again, memes, jokes, cussing are all forms of internal hostility. Whether you are aware of your anger is on you, but it's very clear to see. Okay. What do I have to be angry about with you? Your content, you're free. Free money for me. And you thought your memes and banter were all just play. Now that is cute. Here we go. Memes and banter, guys. That means you're angry. It's all internal hostility. Memes and bants. So I laugh. Said, but you said you would leave me alone if I named one time I've sought out breakdowns in law to prove the use of gun force was wrong. I mentioned Michael Drejka. Wait, this is where I realized it. Right here, 1:43 p.m. You might not actually know that I'm a lawyer. Did you not know that I'm a criminal defense attorney? Well, you've said a lot of things I can report so far. Apparently, you can report me, I guess. I don't know what I've said that's reportable, but the fact you're having to try and tell me you're a lawyer is funny. What's even funnier is your case selection thinking you're doing anything other than confirmation bias. I went through your last few weeks and everything is just a hand-picked case that is set up for you to prove how the right wing is correct. Potter? I guess is what he's talking about. Rittenhouse? He just said Rittenhouse was right a minute ago. Past few weeks has been Potter and Rittenhouse. I don't know what else I've been talking about. So I have to tell you, I'm a lawyer because you're obviously unfamiliar with me and reading my media Twitter account. You asked if I sought out breakdowns, which implies you don't know that I'm fully capable of breakdowns of law. You don't seem to be aware that I run a legal commentary channel that discusses all sorts of cases. Your incessant use of right wing is interesting because it indicates you have some bias in the opposite direction. I mention it because you don't seem to know. Did you know? All I know is you've said tons of things to me I should report. And for someone trying to make fun of whatever it was of the use of the word right wing, your entire page is dedicated to figuring out how Republicans, the right wing, can justify a decision in their favor. If I in any way, shape, or form thought your page was close to objective, I'd have never responded. Look at your entire page. Remember, they just looked at a couple weeks, apparently. It's all just trying to figure out some public case to confirm the right is right. Even starting to cry and muddle how excited you are Roe versus Wade should be overturned. It should be. It's bad law. Again, whether you want to have abortion in your states is up to you. You even wrote that Fauci is a madman. The guy is legitimately one of the most well-respected scientists in the entire world. I had to check myself right now. I thought he's trolling. He's got to be trolling. Again, Fauci is one of the most well-respected scientists in the entire world. Fauci is a politician. This guy thinks he's one of the most well-respected scientists that exists. He's a politician. He's an administrator. The scientists are employed by Fauci. You'd sit here and say banter just to justify how nonsense that was. Ha! I represent science, not a madman. Okay, bud. Your analysis of my page isn't relevant to me because your analysis is shown to be deficient anyway. To get an 80,000, here's the thing. To get an 80,000 page to respond this many times, my analysis was hella relevant. Okay, cool. And yes, as you may be wondering at this moment, all of your analysis and critical thinking is drenched in subjectivity and bias. And it's why you wouldn't even sit there and try and piece together a case which doesn't serve some self-interest. Ahmaud Arbery was going on at the exact same time, and all I could find is one post in which you retweet something about the case which didn't go anywhere nearly as planned. Yeah, I was watching Rittenhouse the entire time. And first of all, I don't know that I ever suggested the McMichaels would not be found guilty. In fact, if you want to know who did on this channel suggest that the McMichaels would be found not guilty, it was Andrew Branca, who came on the show, and I talked to him about it, and he made a self-defense argument for the McMichaels. This was before a lot of facts came out and well before the trial. I'm not blaming him for his analysis. His analysis was very interesting at the time. You should go check it out. Very, very good show that we did a long time ago. But yeah, I don't know that I was ever on team McMichaels are fully innocent. I thought they'd be convicted most of the time, but okay. It's so obvious what your agenda is in all this. How could you literally never mention that case? Oh, I know, because it doesn't suit your agenda. But it wasn't literally never. You just said. I retweeted it. My friend was covering it. Carl Job says, I'm reading Fauci's history. He might be legit, though. He appears to have been a scientist. Yeah, I'm sure he was, right? Like he's a doctor of some sort. And but you get to administrative positions in science by being a scientist, and then you move out of that to doing policy. And then you argue with Rand Paul over and over. You argue with Rand Paul, who's wrong about everything. All right. Anyway, so that's the fun encounter with the PKM cards, who then blocked me. I don't know if you saw that. I guess I should bring that back up. They sent this and then blocked me. I don't know what I did. They swiped left at the end of the day. By the way, guys, Carl Jobst in the chat, good friend, good dude. Definitely check out his channel. He is into a lot of stuff. A true video games journalist, and covering very, very interesting stories. Has gotten himself on the bad side of a man named Billy Mitchell, who's really mad about Carl reporting on facts. And so, but yeah, definitely check out Carl if you're not familiar with him. Also his Minecraft speedruns are like, make me sad because I will never play Minecraft in that way. Woo. So there you go. That's the PokeMoron. Next, we've got Jason of the Great Awakening saying, memetics is literally the formal definition of symbolic communication in AI, totally not understood by the left in their centralized control structures and narratives. Yeah, no, memetic communication existed well before internet memes became a thing. Did you finally watch his vids on the possible rigging in the collector's market? No, I have not. But I heard he worked with Legal Bytes on that, and everybody should check that out. Everybody should. I need to. My backlog of videos I'm supposed to watch is so long. Trouble Lord says, hook up that plow. Also take my money. Keep up the work. Mandy Carvica says, just got home, Nick. Can you please give a 6-word recap on every single tard you talked about for the past 2 hours? Thank you. They don't understand these dank memes. Bam. There you go, Mandy. 6 words to describe everybody I've talked about in the past 2 hours. Whew. Okay. Okay. Is Neerman gonna steal my grifter crown? He can try. But if you're gonna take a swing at the champ, you better not miss. You better not miss. You can't outgrift me, boy. Don't even try. Oh my goodness. Hey, Carl, do you drink I can't remember from our interview. Do you drink scotch or whiskey or anything? If you're still there? Melinda Scott says reported. Thank you, Melinda. By the way, guys, you want to talk about fair? I had Melinda Scott, the actual one from the lawsuit, the celebrity suer. Suer, not Sewer. I mean, maybe both. I had her call into this show. She called in one time. It was amazing. It was amazing. Like I've had lots of people on the show. I've had Tim Pool on the show, you know. I've had Carl Jobst on the show. These are big celebrities. Getting Melinda on the show was creme de la creme. Had Sargon of Akkad's been on the show several times. Tons of people on. Tons of people. But Melinda, how do you even pull that off? Okay, call me straws. Now, calm down. Calm down. Ride the joke. Ride the joke. Yep, had Vic on the show, of course. Should we listen to a little bit more of these abortion arguments? Had Tonka on the show. Tonka, oh my goodness. Had Jim on the show. If you're in the right corners of the internet, these were at the time, these were serious names. I mean, Jim is still Jim. Jim's great. I had Ethan Ralph on the show one time. I did. He got canceled. I invited him on right away. I'm like, hey man, come on, talk about being canceled. I never did nothing for the kill stream though. I haven't had Bearing on the show yet. I should. He's been in the chat. I should invite him on sometime. Didn't Jim live stream tonight? At some point, we're going to get Ghetto Gaggers Duke on the show. That is. Whew. Had the. No, I did not have Anthony Fantano on this show. I went on Anthony Fantano's show. That's right. I was on Fantano's show, but he stopped responding to me. Anthony Fantano asked me before I went on his show, he said, hey, wait, am I going to find out that you're some like horrific alt-right monster? And I said, no, of course not. What are you talking about? Then he had me on the show, and then like he never had me back, which I thought was rude. Had Quartering on the show, Pasovic, Will Chamberlain. It's always amazing to me, by the way. Helen Dale, the audio on that one's all screwed up. I was such a baby streamer back then. Helen Dale's a really interesting figure. acclaimed author, writer for Quiet. Stephen Gutowski, the Second Amendment journalist, Stephen Gutowski. He's fantastic. I got to get him back on, by the way. He is a really interesting character. TJL, yeah, I had Helen Dale on my show. Had Razor Fist on a couple times. Love talking to that guy, by the way. I should talk to him about that shooting in Arizona. Say, what the hell's going on? Had Arch on. Louis Laveau. Bob Piffle says, just got home from me local wonderful dive bar just north of Chicago. Got to do it. Stranded Island quiz. Favorite album. Favorite beverage, food. Favorite movie. Cheers. One last Maker's Mark. Okay. Favorite album. Stone Temple Pilots. Purple. If you get one album to bring on the island, Purple. Favorite beverage and food. Beverage, I'm going to take sweet tea all day. Many of you would think I'd take liquor, but I'm going to take sweet tea. And then for favorite food, I'll pick ramen. Ramen all the time. And then finally, favorite movie. If I had to watch one movie over and over for all time, I'm going Starship Troopers. No, Mandy, I like Core a lot. I like Purple a little bit better. I like Purple a little bit better. What's a good instant ramen? Nissin Rayo shoyu flavored ramen. Don't get the tonkatsu. I don't like that one. The Nissin Rayo shoyu ramen is a great instant ramen. All right. I love Shangri-La. I like actually all of the first 5 Stone Temple Pilots albums. Core, Purple, Tiny Music, Number 4, and Shangri-La. I love them all almost equally. Almost equally. Starship Troopers says everything you could want, by the way. It's got nudity. It's got obscene violence. It's got hilarity. It's got satire. It's got Doogie Howser. I mean, I don't know how you go wrong with Starship Troopers. Favorite song on Purple is... I think it's called Down the River, right? Sail Me Down the River. Is that the one I'm thinking of? I got to get that track list. It's a deep track. Still Remains used to be my favorite song. Oh no, the Down the River, I think that's actually on that's on Core, right? Yeah, I think it Still Remains is my favorite song on Purple. Okay, what am I doing? What am I doing here? Should we do some of these Supreme Court abortion arguments? I'm a little bit into it. Oh, that's Unglued? God, I love Is that the song? Somebody told me I know where to go. That one? That's is that Unglued? All right, let's do these Supreme Court arguments. Sorry. I'm drinking. I'm drinking. All right. Bob Piffle says, great answers. Keep on going. Keep on keeping on. James B, thanks for the donation. Thank you guys. All right, let's do this. Here we go. I'm going to go back just a little bit here. see where we're at. This is Sotomayor. This is a mentally handicapped Supreme Court justice. Come on. I broke it. God damn it. Just a second. By the way, singing into this microphone with these settings is a terrible idea. I know it sounds terrible. I mean, I'm sure I don't sound great in general, but singing into this with a, because I have this down mix to mono. It is not set up in any way to pick up singing. The noise gate's too high. It's a mess. All right, so we're here. Sotomayor is talking. Joseph says, please don't do it again. Don't tempt me. Don't tempt me. Stick to the Kermit voice. What's that song by 9 Inch Nails? I want to fuck you like an animal. I want to feel you from the inside. That one, Kermit can sing. Kenneth Brown, Nickelback Animals is actually, I like that song, you know, and I know super gay to like Nickelback, but Animals, good song. I don't know how to do that as Kermit. I'm not going to try. So Sotomayor, I talked about this earlier today. I'm not going to belabor the point, is mentioning that Marbury versus Madison is an extra constitutional decision by the court. And it's interesting because the court took power that it didn't have. It's outside of the Constitution, to come back and say that the other branches of government were not allowed to go outside of their constitutional power. Is perfect. You can't hear it. Fuck me. Oh my gosh. Sorry. I kept it. There's no video, so I just had the audio playing, assuming you could hear it.
To individuals, and the states can't intrude on them. We've recognized them in terms of the religion parents will teach their children. We've recognized it.
I was really doing you a favor. You didn't have to listen to Sotomayor's really shit argument here.
In their ability to educate at home if they choose. They just have to educate them. We have recognized that sense of privacy in people's choices about whether to use contraception or not. We've recognized it in their right to choose who they're going to marry. I fear none of those things are written in the Constitution. They have all, like Marbury versus Madison, been discerned from the structure of the Constitution. Why do we now say that somehow Roe versus Casey Roe and Casey are so unusual that they must be overturned?
Well, Justice Sotomayor, I would emphasize two things. When you're going beyond the Constitution, this court has looked closely to...
No, what I'm saying is they didn't go beyond the Constitution.
Your Honor, they did not deduce those from the structure of the Constitution. They pointed to the 14th Amendment and reasoned that privacy in Roe, autonomy and similar values in Casey led to a right to abortion. That's not how this court traditionally does things, including in the vast run of cases that Your Honor ran through. The court looks to history and tradition, and here those decisively reject the proposition that states cannot legislate comprehensively on abortion before, after viability, and all throughout. So it's history and tradition, Your Honor. And I would also add, Your Honor, that those decisions, a great many of them draw, not just draw from text, history, and tradition, but they draw often clear lines, very workable, have not led to the many negative stare decisis factors that we identify here.
I don't know the name of the lawyer speaking to Sotomayor. He's the attorney. He's the attorney representing Missouri. Maybe Missouri Solicitor General or Attorney General. I don't know. Maybe it says on the description, but I don't think so because PBS is a bunch of shit. It does not. Mandy Karvikis says, live lawyer karaoke on YouTube, please. Maybe on Twitch. James B says, watch Marine rapper Dear Kyle sick as fuck video on this YouTube. Show it live. Also look up Ryan Upchurch about a single officer stalking him through social media for 6 months with video evidence. I'm not going to do his music video live. No, that gets in trouble.
General, go ahead.
Go ahead, Dr. Barrett.
James B says, sorry, drunk.
Decision in your favor, call any of the cases, this
is Amy Coney Barrett,
that Justice Sotomayor is identifying into question.
No, Your Honor. I think for a couple reasons. First of all, I think the vast run of those cases, and some mentioned from time to time, I think Griswold, Lawrence, Obergefell, these are cases that draw clear rules. You can't ban contraception, can't ban intimate romantic relationships between consenting adults, can't ban marriage of people of the same sex. Clear rules that have engendered strong reliance interests and that have not produced negative consequences or all the many other negative stare decisis considerations we pointed out, Your Honor. Also, I'd add, none of them involve the purposeful termination of a human life. So those two features, stare decisis and termination of a human life, Your Honor, puts all of those safely out of reach if the court overrules here.
Okay, so one of the critical arguments, it seems, is it Mississippi or Missouri? I think it's Missouri, but maybe it's Mississippi. Doesn't matter to me. One of the states with M's and S's in it. One of the critical claims that they're making is that this is the only constitutional right that necessitates the ending of a human life. Abortion is the only one that does that. Your Third Amendment rights don't end a human life. I mean, they can. Your Second Amendment rights can end a human life. Fourth, fifth, sixth. I guess if you hire a lawyer that murders you on your Sixth Amendment right. But none of them necessitate the ending of a human life. The right to abortion, exercising that right, does. So part of their argument is that this is a unique characteristic of this and that is relevant to the legal analysis that the court will do. The Supreme Court gets to consider basically whatever they want. They're the Supreme Court. They can fit anything in with enough writing. So they're arguing and urging the court to consider the fact that this right's execution, and he hasn't said this, and I think maybe he should, maybe he does later, but the preamble to the Supreme Court is the Declaration of Independence, or the preamble to the Constitution is Declaration of Independence, which enshrines the right to life, right? Life, liberty, and the pursuit of happiness. This is the only Supreme Court or the recognized right that necessitates a violation of the right to life. And it may be, you may not think that someone has a right to life until they pass the cervix or whatever, and that's fine. I'm not here to argue or convince you, but recognize the distinction between that and every other right recognized by the court and recognized by the Constitution.
Okay, so I'm sorry to interrupt again, but we really might be making progress. I mean, in the part that I read, of Casey,
Yes, Your Honor.
I think they think go back 150 years, maybe now we could go back 200. They think there have only been two cases, which were what they call the watershed, and where the special tough overruling rules apply. You want this to be the third? Or do you think there were more? And if so, what were they?
Well, Your Honor, I think
That's Justice Breyer. That's Breyer. He says basically that there, at the time of Planned Parenthood versus Casey, 1992, there have only been 2 watershed moments where stare decisis has been significantly and directly overturned. So he says, if you think there's more, what are they? Let me challenge you on that point.
I think there's quite a bit of difference. I think the question is never, is it bad to overrule, period? Surely stare.
I'm asking you to think in their terms. There were 2 they mentioned, you say. And they don't want Casey they don't want Roe to be the 3rd. And now, in your opinion, you just answered Justice Barrett, or, hey, all these are not rising to that level. Okay.
Right.
Are there any that do rise to the level, in your opinion?
I think, and I'm not sure that I necessarily agree with the watershed characterization, Your Honor. What I'd say, though, I can't think of another that kind of hits the radar, but I'd emphasize that a problem here is we're dealing with a right that doesn't have a basis in constitutional text, and again, very much in conflict with those values, Justice Breyer.
Very important distinction here. My friend Stephen Birch on Twitter mentioned this, and I retweeted it. So if you follow me on Twitter, you might have seen this. But this is a critical difference between Roe and everything else. Roe is not based on anything. You may think Roe is correct, and that is a fine position to take. I'm not here to convince you otherwise. But Roe isn't actually based in the Constitution. It's not based on stare decisis. It doesn't have a history in English common law. It doesn't have a history in French common law. Roe is this generation. Bam! 1972, I think, is the decision in Roe. Creates a right that is not present anywhere else. So he's drawing another distinction here. Okay, yeah. Roe is this thing that exists, blah, blah, blah. But these other cases have prior existing rights. They have prior basis for their existence. Roe doesn't. So they treat Roe as sacrosanct, as it. And again, someone needs to write a book about the history of Roe versus Wade's influence, not about the case at all. There plenty of people have written about the case, but about how it changed and is unique amongst legal jurisprudence. Roe is treated as untouchable in a way that no other decision is. And not only in a way that no other decision is, but it has no basis. It was literally a fabrication. They're not drawing in they're not expanding a prior decision. They're not going off of language in the Constitution other than this, like Ty said, it's almost like a seance. They're mentioning penumbras and eminence in the decision. It's weird. And for that to be given preeminence over any other Supreme Court decision it's a characteristic.
I'm not sure how your answer makes any sense. All of those other cases, Griswold, Lawrence, Obergefell, they all relied on substantive due process. You're saying there's no substantive due process in the Constitution, so they're just as wrong according to your theater.
No, Your Honor, we're quite comfortable with Washington versus Glucksberg and how it analyzes substantive due process, and it looks to text history. It looks at history and tradition to discipline the inquiry and make sure.
I mean, in Obergefell, there was no history of same-sex marriage.
And I think the court.
But there's a history of same-sex protections that predate Obergefell. This is an absolutely incorrect analysis by Sotomayor. Obergefell, sure, it's new to protect same-sex marriage. But first of all, you have Loving versus Virginia, which changes the definition of marriage in general to include and encompass interracial marriage, something that was not done prior to 1970, whatever. Loving versus Virginia was miscegenation. That was done there. Plus you have, I think it's Franklin. Is it Franklin in Texas, which says that sodomy laws that unfairly target homosexuals and are only applied against basically homosexual men are not constitutional. You have these protections for homosexuality, stemming up in other court decisions and saying that basically is a category or class that is subject to protection under the 14th Amendment. You have a pre-existing thing. In Roe, you don't similarly have this.
Pointed out, look, when we were facing Loving versus Virginia.
I'm not trying to argue that we should overturn
Loving
those
versus
cases.
Virginia.
I just think you're dissimulating when you say that any ruling here wouldn't have an effect on those.
Respectfully, that's.
Do you think that no state is going to think otherwise? That no people in the population aren't going to challenge those cases in court?
I mean, Your Honor, we'll always have a diversity of views, but I think
That's the point.
I think that's one of the benefits of our society.
Isn't that the point?
No.
That there's a diversity of views and people can vigorously debate and make decisions
Exactly, and
themselves.
that's
I
what
think
we're
that's a good
still
thing, Your
doing,
Honor.
and that's what we're doing under undue burden, but we haven't been doing it on the viability line.
And neither one has worked well. The viability line discounts and disregards state
Imagine being a Supreme Court justice and getting absolutely manhandled by a random lawyer from the Southeast United States.
interests, and the undue burden standard has all of the problems that
How
we've
is your
emphasized.
interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time.
How is your interest anything other than a religious view? The interest of when life, this is the same phrase. The interest of when life begins has been debated by philosophers since the beginning of time. Well, gee, I don't know, Judge. You just said it was a philosophical question, not a religious one. Thank you. Checkmate, you moron. Sotomayor, on this issue, I don't know about other issues, on this issue is absolutely colossally fucking stupid. I would say it to her face. On abortion, Sotomayor, you're a fucking moron.
It's still debated in religions.
Philosophy is not religion. Religion has a philosophy, but philosophy exists outside of religion. And she doesn't even seem to know that.
So when you say this is the only right that takes away from the state the ability to protect a life, that's a religious view, isn't it?
No.
Because it
Respectfully.
assumes that a fetus is life at when? You're not drawing when do you suggest we begin that life?
Your Honor,
If he's smart, he says, I don't suggest, but the legislature has a right to.
aside from
Putting it aside from religion.
I'll try to. I think there might be more than one question, and I'll do my very best, Justice Sotomayor. I think this court in Gonzalez pretty clearly recognized that before viability, we are talking with unborn life with a human organism. And I think the philosophical questions Your Honor mentioned, all those reasons that they're hard, they've been debated, they're important. Those are all reasons to return this to the people, because
And I got to point out, the court's view of abortion since Roe versus Wade is not actually scientifically based. It's based on Middle Ages ideas like ensoulment or the quickening. It's based on the idea that life does not exist inside a fetus, which they didn't know was a fetus back in the Middle Ages. Life does not exist inside this growing thing until something happens, until God breathes a soul into the womb of the mother, and that enters into the baby. That is where fetal viability ultimately comes from under Roe. Now, in Planned Parenthood versus Casey, it's moved down. This is an anti-science position that has been trotted out as scientific, but it's actually not, because the idea in Roe is that that's not actually a baby until 2 trimesters in. We don't know what it could be. It could be cancer, could be broccoli, could be cheese. I don't know. How could I possibly know? It's Schrodinger's fetus, right? The lunacy that has happened here as we've advanced to recognize that human DNA exists in completeness at conception, which I actually don't think is a good starting point for life. I think implantation is a little bit better. because there are actually conceived embryos that are naturally shed all the time. Implantation's a little bit of a different phase. Now, are they distinguishable easily? Not really. From the most part, conception and implantation are going to occur within a relatively short amount of time. You're not going to notice a difference. By the time you know you're pregnant, you're going to be implanted anyway. But that being said, I mean, there are distinct points in development that we could determine, or that more importantly, a legislature could determine life begins. That's the argument, though. The argument is not that life begins at conception or implantation or at 10 weeks or at 20 weeks. The argument is that the legislatures of each state gets to determine when their interest in protecting that life is. That's the important part of this argument. And that is what Roe has actually taken from the state. When does the state, and that's what Roe is about, by the way, the conflicting interest between a mother's right to privacy and bodily autonomy versus a state's interest in protecting a life that will be born if otherwise left unmolested. The state gets to define what that is up until Roe is decided. Once Roe is decided, it says, prior to 2 trimesters, you can't do it. Once Casey comes in and refines it, prior to fetal viability, you can't do it. It's not about when life begins. It's about the state's ability to determine when they will step in to protect life on behalf of that potential life.
The people should get to debate these hard issues, and this court does not in that kind of a circumstance.
So when does the life of a woman and putting her at risk enter the calculus?
Pregnancy is one of the lowest risks. Pregnancy and delivery is one of the lowest risk medical procedures out there currently today. And the interesting thing is, many states allow abortions up to the point where actual cesarean delivery would be a viable alternative to an abortion. That's the crazy part about where we have progressed scientifically. And again, where does the state get to step in and say, hey, we want to protect this baby?
Meaning, right now, forcing women who are poor, and that's 75% of the population.
75% of the population is poor. Not only 75% of the population is poor, but 75% of the population is poor women. These are the quality statistics you get from Justice Sotomayor. 75% of the population is poor women. The hottest of takes, the brilliantest of statistics, the mostest of science.
And much higher percentage of those women in Mississippi who elect abortions before viability, they are put at a tremendously greater risk of medical complications and ending their life, 14 times greater to give birth to a child full term than it is to have an abortion before viability.
The amazing thing is that sounds like a big risk. Oh, it's 14 times greater. The risk is so catastrophically low that stat is basically meaningless. If it's 1 in a billion, it's 14 in a billion, right? Oh, wow. That's a lot.
And
it's also
now
inaccurate.
The state is saying to these women, we can choose not only to physically complicate your existence, put you at medical risk, make you poorer by the choice.
We're not choosing this, by the way. The woman is. Let's be honest about this. Ladies, you're the gatekeepers of sexuality. If you don't open those legs, pregnancies don't happen, except the rare case where pregnancy is conceived in rape, which of course is a tragedy and a completely unrelated question to this, even though it's brought up more often than is merited.
Because we believe what? That
Sure, Your Honor. I think to answer, I think the question I think you led with, and then I think it expanded on, but is still on the same issue, is as to when does a woman's interest enter. As far as we're concerned, it's there the entire time. Our point is that all of the interests are there the entire time, and Roe and Casey improperly prevent states from taking account and weighing those interests however they think best. We're not saying—
General, are there secular philosophers and bioethicists who take the position that
I think that's Gorsuch.
the rights of personhood begin at conception or at some point other than viability?
I believe so. I mean, I think there's a wide array, I mean, of people of kind of all different views and of no faith views who would reasonably have that view, Your Honor.
Oh, that's Alito? Okay, thanks. Thanks, Uncivil.
All right, it's not tied to a religious view, and I don't think
I don't
were
listen
it
to these
otherwise, this
dummies.
court's jurisprudence would, on this issue, would run right into some of its religious exercise jurisprudence.
General, Justice Breyer started with stare decisis, an important principle in any case, and here, for the reasons that Casey mentioned, especially so, to prevent people from thinking that this court is a political institution that will go back and forth depending on what part of the public yells loudest, and preventing people from thinking that the court will go back and forth depending on changes to the court's.
This sounds like Kagan. Benevolent Soul says, Nick, you really went there? What? Like, I don't listen to these guys. Like, I don't recognize their voices for the most part, is what I'm talking about.
Membership. And what strikes me about this case, and you come here very honestly, saying, you know, we want you to discard.
Yeah, who believes the court isn't political, by the way?
The entire setup. And then even if you don't do that, we want you to discard the viability line, which you've acknowledged again today. Casey says is the heart, the central principle of Roe. And so
an important argument from earlier is they talk about that viability in Roe is basically dicta. It's a throwaway section. And then Casey comes along in 1992 and says that viability is actually the central premise of Roe, which is great. And Kagan here is talking about that. But again, it goes to the lunacy of these two cases being the controlling abortion law and to the fact that it's entirely made up. The reason viability becomes the most important part of Roe, the critical factor, even though it's basically a dicta paragraph in the case, is because it becomes their best argument 20 years later when Casey is decided. Because they're like, oh, well, shit, all of these other arguments that we had don't really make any sense. But viability, oh, yeah, there we go. We'll throw out this viability line. It'll theoretically decrease as medical technology increases. Viability will get earlier and earlier and earlier. And then that'll be perfect. That'll settle everything. Let's just see how we are. Let's see how we go in the future.
usually there has to be a justification, a strong justification in a case like this, beyond the fact that you think the case is wrong. And I guess what strikes me when I look at this case is that, you know, not much has changed since Roe and Casey.
Yeah, not much at all.
People think it's right or wrong based on the things that they have always thought it was right and wrong for.
Not true.
So the rationale behind those cases has something to do with the autonomy and the freedom and the dignity of women to pursue their lives as they wish, to protect their bodily integrity, to make the decisions that are most fundamental to the course of their lives. And always in those cases, there was an understanding that there were important interests on the other side in protecting life or protecting the potential for life, whether people saw it one way or the other way, and that there was a difficult question here and a balance to be made. And I mean, it strikes me that some people think those decisions made the right balance, and some people thought they made the wrong balance. But in the end, we are in the same exact place as we were then, except.
So bodily autonomy. Think about this: weed, heroin, cocaine, LSD, ecstasy, Sudafed, right? Pseudoephedrine. You have bodily autonomy? Really? Do you? Do you have bodily autonomy? Provigil, Ritalin, vaccines. I haven't even gotten to vaccines, but I was avoiding it at first for a very specific purpose. This idea of bodily autonomy. Why can't I put why can't I put what I want in my body?
That we're not, because there's been 50 years of water under the bridge, 50 years of decisions
Flint water?
saying that this is part of our law, that this is part of the fabric of women's existence in this country.
Women, just know, by the way, that people like Elena Kagan and Justice Sotomayor, they believe that your existence, core to the fabric of your existence, is Roe versus Wade. That abortion is core to the fabric of women's existence. Kagan just said it. They all believe it.
And that places us in an entirely different situation than if you had come in 50 years ago and made the same arguments. So I guess I just wanted to hear you react to that.
Of course, Justice Kagan, thank you. I would emphasize a couple things, Your Honor. The fact that so much time has passed, let's say nothing had changed. That's not a point in Roe and Casey's favor. They have no basis in the Constitution. They adopt a right that purposefully leads to the termination of now millions of human lives. If nothing had changed, they'd be just as bad as they were 30 years ago, 50 years ago. And now we just have decades of damage, and we have a situation where nearly 30 years after Casey, the court unfortunately divides over what Casey, the lead case in the abortion area, even means.
Real quick, ladies, if you think you have bodily autonomy, by the way, try being a prostitute. One of the aspects of property rights is the right to alienability, the right to sale. You can't. You want bodily autonomy, but they won't let you sell sexual intercourse. Why not? What legitimate government purpose is there in you, an adult, cannot accept money for sexual intercourse with someone else? I thought you had bodily autonomy, right? What happened to that?
The lower courts are left not knowing what to do, as I think kind of a fundamental problem here is, I think, as Justice Gorsuch mentioned, emphasized in his opinion in June Medical, that the problem for lower court judges is the Constitution doesn't give them an answer to this. There's no neutral rule of law, so judges unfortunately have to look within themselves, and that's just never going to solve this issue. But if the matters return to the people can deal with it, they can work, they can compromise and reach different solutions. But if we don't do that, we're just going to have all this sort of damage, and at some point it's appropriate for the court to say enough, as it has in some of the great overrulings, in Brown and in other cases where it said this is just enough. Justice Harlan had it right in dissent in Plessy when he recognized that all are equal, and similarly here the state should be able to recognize, hey, there are real values on both sides here. We think that this one slightly outweighs, that we think that this one slightly outweighs, or we think that there's some balance to be drawn here. But if the court doesn't do that, Justice Kagan, it's just going to be continued damage. And
I did not fall asleep. Sorry, there's a thing on my leg. I don't know if it's like a ingrown hair or whatever. I was looking at it.
the court will continue to plunge in this political issue. I apologize, Mr. Chief Justice. I've gone over.
No, that's all right. I have just a few little, well, not little, I hope, questions. And the first gets back to the issue of viability. You know, in your petition for cert, your first question, and the only one on which we granted review, was whether all pre-viability prohibitions on elective abortions are unconstitutional. And then I think it's fair to say that when you got to the brief on the merits, you kind of shifted gears and talked a lot more about whether or not Roe and Casey should be overruled. And I wanted to give you a chance to explain that.
Sure, Your Honor. So a couple points. At the petition stage, we were, of course, we'd identified for the court 3 questions. We emphasized, as you do at the cert stage, hey, this is important. Only this court can resolve it. We emphasized, I believe it was 5 times, that the court was at the least going to need to reconsider, revisit, or reevaluate its precedents. And we asked the court to at least get rid of a viability line or any suggestion of a viability line. So we added, however, and we had to take account of the reality that this argument has not fared well in the lower courts. It's lost in every court of appeals. So, we raised the issue in addition, but once the court granted only the first question, we presented every argument as we, signaled we would present the full-blown constitutional merits argument with that fundamental question. So I'd emphasize that, Your Honor. It was kind of the shift. You go from cert stage to merit stage. The court granted one question. That question fairly includes what is the correct standard.
Well, it fairly includes the broader arguments you raised. I'm not suggesting that. But on the other hand,
So what's going on here is Roberts, who's a turbo cuck, is saying, well, we only granted you Supreme Court review on this one argument, but I think it's fair to say that you raised other arguments beyond that question. And so therefore, why should we consider them? And he's like, no, the whole argument matters for just the one question, Your Honor, with respect, with all little due respect.
and it presumably included the viability question as well, because that's what you talked about in that one sentence.
And we've addressed that as well, Your Honor. What I'd emphasize here is that the merits arguments of, the validity of Roe and Casey as an original matter, is there a viability rule based in the Constitution? Those are not that complicated or lengthy. The harder questions are, should the court overrule and take that momentous step? And that's why we devote a lot of space to that very important issue. We respect stare decisis and have walked through all those points, but again, focusing on the question presented and presenting our best arguments for that, that's what we've done, Mr. Chief Justice.
On stare decisis, I think the first issue you look at is whether or not the decision at issue was wrongly decided. I've actually never quite understood how you evaluate that. Is it wrongly decided based on the legal principles and doctrine when it was decided, or in retrospect? Because Roe, there are a lot of cases around the time of Roe, not of that magnitude, but the same type of analysis that went through exactly the sorts of things we today would say were erroneous. But do we look at it from today's? If we look at it from today's perspective, it's going to be a long list of cases that we're going to say were wrongly decided.
Well, I'd say
if they're wrongly decided, I don't care how many there are, they're wrongly decided.
I'd say, Mr. Chief Justice, that you can look both. Was it wrong at the time? Has it been unmasked as wrong by new understandings, new knowledge, and any developments? But I don't think, as I think my colloquy with Justice Barrett indicated, the court won't have to be looking at many other areas, because this is an area that has a uniquely problematic set of stare decisis considerations. A lot of other controversial areas, or once controversial areas, are quite settled, clear rules, and don't have those considerations against them. So really, by overruling Roe and Casey, the court won't have to go down that road, and a lot of those decisions are quite readily groundable in history, tradition, and the court's traditional factors, Your Honor.
Thank you. Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor? Okay, Justice?
I just wanted to get your quick sense of how your intermediate
When his portion is done, I'm going to wrap up.
positions would work. If basically the viability line was discarded and undue burden became the standard over.
Thomas actually started questioning at the very beginning, earlier in the case, which I listened to earlier. He's in the first 10 minutes. He's actually opens the questioning.
Overall, a standard that, according to you, is an unclear one. What that would leave the court with going forward. I'm just sort of thinking about the great variety of regulations that states could pass. So whether one is 15 weeks and one is 12 weeks and one is 9 weeks, or variation across a wide variety of other dimensions, what would that look like coming to the court? How do you think we should we would be able to deal with that, or how would you counsel us to deal with that if the court were to go down that road?
Well, I think this is not to push back against the end, and I will answer your question, Justice Kagan, but part of why we've counseled to overrule full scale is that that's the only way to get rid of a number of the problems that I think Your Honor is alluding to. And that's that when you have the undue burden standard, it's a very hard standard to apply. It's not objective. The court looks to the record in each case and what's going on. I mean, the court in Casey itself said under this record, this is not an undue burden. You couldn't say necessarily for certain that a certain number of weeks one place would be an undue burden, but would be okay another place. But again, that is the world we have under Casey. So if the court upholds this law under the undue burden standard, it would be carrying forward those features, which and I hope I've answered your question, but I think that's one of the very strong reasons to just go all the way and overrule Roe and Casey, Your Honor. Anyway.
Justice Gorsuch? Justice Kavanaugh?
I want to be clear about what you're arguing and not arguing.
Yeah.
And to be clear, you're not arguing that the court somehow has the authority to itself prohibit abortion, or that this court has the authority to order the states to prohibit abortion, as I understand it, correct?
Correct, Your Honor.
And as I understand it, you're arguing that the Constitution's silent and therefore neutral on the question of abortion. In other words, that the Constitution's neither pro-life nor pro-choice on the question of abortion, but leaves the issue for the people of the states or perhaps Congress to resolve in the democratic process. Is that accurate?
Right. We're saying it's left to the people, Your Honor.
And so for the, if you were to prevail, the states, majority of states or states still could and presumably would continue to freely allow abortion. Many states, some states would be able to do that even if you prevail under your view. Is that correct?
That's consistent with our view, Your Honor. It's one that allows all interests to have full voice, and many of the abortions we see in certain states that I don't think anybody would think would be moving to change their laws in a more restrictive direction.
Thank you.
Thank you, Your Honor.
Justice Barrett?
General, I have a question that is a little bit of a follow-up to one that Justice Breyer was asking you. That's about stare decisis, and I think a lot of the colloquy you've had with all of us has been about the benefits of stare decisis, which I don't think anyone disputes. And of course, no one can dispute because
I do. I dispute the benefit of stare decisis, but that's me. I'm Dick.
it's part of our stare decisis doctrine that it's not an inexorable command and that there are some circumstances in which overruling is possible. You know, we have Plessy, Brown, we have Bowers versus Hardwick to Lawrence. But
ACB's like, yeah, stare decisis exists, but part of the doctrine says we can overturn it. Whoever asks how many dislikes there are currently 35. It's a pain for me to check. They don't tell me straight out the gate. I have to go to a different page to find it. James B says, for everyone here, are you hiring and what position? Also, what positions? More specifically for combat veterans in product and project management. So there you go, guys. If you are hiring currently, it looks like James B is looking for some information on that.
in thinking about stare decisis, which is obviously the core of this case, how should we be thinking about it? I mean, Justice Breyer pointed out that in Casey, and in some respects, well, it was a different conception of stare decisis insofar as it very explicitly took into account public reaction. Is that a factor that you accept? Or are you arguing that we should minimize that factor? And is there a different set of rules? It is true that Casey identified Brown and West Coast Hotel as watershed decisions, but is there a distinct set of stare decisis considerations applicable to what the court might decide as a watershed decision?
I don't think there should be a distinct set of considerations there, Your Honor. I think what I emphasize, and just to make sure, on the kind of legitimacy, the court looking outward, I think Casey was unusual in that regard. I think it was a mistake, and I think it's something that is kind of in conflict with this court's structure and approach as an independent branch, looking to the Constitution rather than looking without. And I think that's one reason why traditionally the court is in some of its greatest overrulings, it's not looking without. It's saying this was wrong. It was wrong the day it was decided. We know it's wrong today, and it's led to all these terrible consequences. We should get rid of it. So I think that was an unfortunate break, and I think the court, even if the court were to still look at legitimacy, though, Justice Barrett, I think the court could very, very powerfully say, look, our legitimacy really derives from our willingness to stand strong and stand firm in the face of whatever is going on, and stand for constitutional principle and follow our traditional stare decisis factors to overrule when it's appropriate. Thank you, Your Honor.
Thank you, counsel.
Thank you, Mr. Chief Justice.
Ms. Rickleman?
All right, that's the state of Mississippi's argument and response to questions from the justices. I can't go through. There's an hour and 10 minutes of this left. I am not going to go through it right now. I need to wrap up because I got to be up in 7 hours. Actually, no, I have to be teaching in less than 7 hours, so I got to be up in 6.5 hours, 6.25. So we'll probably be delving more into this topic as we go. I think the questions coming from Amy Coney Barrett indicate that she seems to be willing to overturn it. Obviously, Kagan, Sotomayor have no interest, and Breyer have no interest in overturning Roe versus Wade. The question is, will Kavanaugh or Gorsuch flip with Roberts? Because I think Roberts will flip to the liberal side. I do. I don't think Roberts is keen to overturn Roe versus Wade. I've never thought he was keen to overturn Roe versus Wade. I've never thought he was even at all interested in this. But the question is, will Kavanaugh or Gorsuch flip with him? I think Clarence Thomas, Samuel Alito, and Amy Coney Barrett are solid for overturning it. I really do. Gorsuch, Kavanaugh, Roberts, they're the question marks. So with that, I need to read the super chats and wrap up the show. And that's what we're going to do. Thank you all for hanging out with me. I will play the outro, which I have re-implemented the outro. But I'm going to burn through these because it's really late. I went a little longer than planned tonight. No, there's no Twitch tonight. Again, sorry. I'm short on sleep already. I got to get up to teach, and I owe these kids my ability to give them good attention. Squizgar says, Judge is back. Dark Cookie says, yeet, yeet, I'm here to beat my meat. Mickey Rock says, just got done watching Good Logic's Maxwell trial stream. Great stuff. Overwhelmed by all of you and your peers' fantastic infotainment. Matthew Self says, ooga booga booga in Mr. Richards' voice. Would ya? Anthony Michael says, thank you for all the content through Rittenhouse. Quick question. Do you have any knowledge of the rare breed triggers versus ATF case? Very basic knowledge. Like actually not even right now. I can't even remember what specifically it's about, but I think it's a trigger that basically acts like a bump stock. It uses the physical motion of the gun and to fire off a second shot so long as the person applies constant pressure, but it makes an independent trigger pull mechanism each time. I don't know what's going on in the case, but that's my understanding. So question is this a fully automatic rifle under the definition? Of course it should not be. Of course it should not be. A mechanical trick to make an individual trigger pull happen rapidly should not in any way be an automatic weapon, because in theory, if you could get your finger to move fast enough, it would make it an automatic weapon as well, and that shouldn't count. Poll says, Richards, Your Honor, I'd like to strike this juror. This commie is on team no balls. Trooper says, hey, King, stay based. Thanks to you and the invoice, I get 24/7 live content. I can bounce from you to Drew, Grueler, Joe, top it with Bronca, and wrap up with the night show. Then Twitch, the grift is cozy. Chase Thomas says, justice for Barb Chan. True Ananana Shabbat Bad Pressure Batakafa. Batakafkar says, here's 5 for nighttime, Nick. I love it. Also, don't see how anyone gets through the Potter case without your commentary. It'll pick up when the actual trial is happening. It'll pick up when the trial's happening. But right now, yeah. Whew. Tony Alto says, awesome job teaching kids about the Constitution. Bannable Animal says, Nick, quick question off topic. Sorry, but on a scale of 1 to 10, how deep into the alphabet does Binger go? Just the LG or the BTQ? My money is on pedo. Thanks. Nick D says, hey, Rickay, to have a drink for me. Wish I could join in on the drinking, but I work midnights. I've had enough, and now I need to stop, so I sleep and wake up. Teresa Hoisington says, I've had the ASMR jury selection on in the background while doing Christmas decorations. I love the night show while online gambling and drinking bourbon. Me too. Except for the gambling part. I don't really do that. Mike Hunt says, I mean, I'm not opposed to it. I just don't. While you were sitting here on your butt, drinking and talking from your nice, safe home, Vito, free speech hero and InfoWars guest, is on the front lines fighting for freedom of speech. Vito 42, Nick 0. Leatherman 78 says, watching you rip apart the legal screw-ups of a moron is the best late night entertainment I could ask for. Keep up the good work. Bad Dragonite says, what lost tribe are the Polish people from? The Midianites. Wait, no. The Danites. The Danites. Not the Naphthalinites. Those people suck. Really Now says, still a better storyline than any Steven Seagal movie. You shut your whore mouth. Out for Justice is a masterpiece. Are you duff enough? Well, are you? Says, I only give money when I drink. Well, drink more. Comic Nut 64 says, Killian Yosef Lolcam Ped. I don't know what that means. Amateur Ant says, Melinda uses a Chewbacca defense on everything but manages to lose them all. Alabaster Scarf says, hey, Nick, congrats on the channel blow up. Thank you. Any update on the Vic appeal? Nope. Wasn't the decision supposed to come in October? Well before that. I think September 22nd was the normal rule date, but we have not gotten there. We've not gotten it. So hopefully it'll come any Thursday, 9:30 p.m. as possible, including tomorrow, 9:30 p.m. Central Time. Maybe it'll happen. Jacob says, 4chan banned the film Cuties from Netflix because it considered it child filth. Known Important says, I used to go to 4chan back in 2010. Trust me, when they say cheese pizza, they just mean anime waifus. Gore, scat, and lolly are banned there. Melinda Scott says, Nick, I'm suing you for cyber stalking. See you in court. Sure, lady. Alex Scott Thompson says, lol, okay, so Kiwi Farms, odds of having Medicare on. I've had Medicare on. I happy to have Jim on at any time, but he's dealing with his cancer, AIDS, or whatever. I let him do his own thing. I don't bother him. I appreciate Jim's Twitter account, and I appreciate Jim's videos when they do pop up. I think he's a great entertainer. William Haydick says, welcome to lawyer status. I mean, Athamer says, what a sexist judge. I can't believe he wouldn't censor all mankind just because Melinda is a woman. Truly terrible. One law student says, Nick, Moon doesn't fall under 1332, right? Or is there a 1331 federal question issue? Or is this different because it's a magistrate proceeding? No. She tried to file a 1983 claim, I think, against the state or against CPS, and then just attached Moon to it. But Moon falls under diversity jurisdiction. She's in Virginia. He's technically either in Florida or in wherever he is in Europe. Sorry, I didn't see that earlier, but it's not a federal question issue for Moon. It's defamation in the state of Virginia. She's trying to execute long arm jurisdiction over him by trying to exercise diversity jurisdiction over him. But trying to, yes, similarly exercise long arm jurisdiction. I think he ultimately consented to jurisdiction in Virginia, and is just fighting it there. But yeah, he's out of the country, so it's diversity. Mr. Tech says, are they in any way related to Corn Pop? VBNBNBXMNXFM says, Whistle Pig 12-year-old world rye, great. Green apple honeysuckle licorice with a nice finish of cherry and a light finish of barrel spice. I like the Whistle Pig 12. I like most of the Whistle Pigs. Free Golem says, for some reason, my brain wants a crossover with Nick and John Lovell of Warrior Poet Society. Kimberly Campbell says, 2 cops were stabbed here in India after the suspect called them. Enabled Diamond says, I'm extremely depressed. I'm about to lose everything. Can I get any hope? Yes, Enabled Diamond. You can get hope. You can get hope. Look, losing everything is losing things, which things are very important. Don't ever let anybody tell you they're not, but things can be replaced. Life status can be upgraded. The most important thing to hold on to is you, because you are not replaceable. You are upgradable. You are downgradable, but you are not replaceable. There's no thing you can do to undo the loss of yourself. So don't lose yourself. You don't need to. There's no reason to lose yourself. In the times of loss, focus on you and improving you, not on improving your situation, not on improving your possessions, not on improving your property, but on your person, because that's sometimes all you can do. And you will find fulfillment, inspiration, and motivation in doing so. Do it. Do it. Don't let your identity be tied up into possession. John Parson says, "What smoker do you have?" I have the Smoke Fire, the Weber Smoke Fire. I think it's the 1200 or something. Maybe it's a 900. Garrison Sand says the Richards 4chan thing was thumbs up. Thanks. Ryan Wright, thank you for joining at Paralegal Status. Deep Service says, I heard wheelchair guy was watching replay of Rittenhouse trial at the part where Richards was dropping the shoot me nibla. Really now says Vic is a dude fired from DBZ voiceovers. Yes. 63 Rambler says, Your Honor, I was waiting for the Richard Shakespeare readings and for your stream of Law Tube Posse's joint watching of the Trayvon hoax. You'll see that the Kyle Rittenhouse travesty has happened before. Yeah, the Trayvon hoax, I was in contact with the director of that. I was in contact with the director of that, but I didn't happen. Silverfish 606 says, damn, Nick, spot on impression of Vic's Edward Elric. Thank you. Does this dress make my Arizona look big? Just for a chuckle, on another podcast, you mentioned looking for a new name for the group. A Shiver of Lawyers. Shiver of Sharks is the name for a group of sharks, or a good start. How many lawyers? Jordan E., thank you for joining. Vor says, this PKM cards person brings me much joy, considering my favorite streams were the ones making fun of that crazy chess guy. 13 Speed Demon says, Nick stole this membership chat money. True. Really now says, said it before, massive difference between justified and good shoot. I tell you to leave and you grab my weapon and throw me off my porch, you're done. Dragon Fist says, Nick, SCOTUS may overturn Roe versus Wade. If so, praise the Lord. Anyway, got to go, but we'll watch the replay. Hope you and your fam are well. God bless. I would suggest people don't get too worked up about Supreme Court on Roe versus Wade. I don't think it's actually likely to happen. But if it does, it'll be really damn interesting. And Roe versus Wade being overturned does not actually make abortion illegal in any way, only in states that specifically pass those laws. So that's another sort of misnomer. Not applicable says, realize this thing is allowed to reproduce. Tony Alto says, I so disagree. A couple of seconds is not enough time. We could clearly see the guy making a move towards Kyle before he shoots. Charles Vance says, the law also says removed past tense, which establishes justification for the forceful removal from the habitation. Yep, that's actually part of my argument. Squid says, I think it's fair to say Kyle was justified under the law, but still morally wrong for not staying out of a custody dispute, that he had no physical threats until he brought the gun out. Perfectly reasonable position. Tony says, Bronca admitted his idea is nullified if Chad was moving towards Kyle. So hopefully another video is out there with better clarity and the ability to frame forward that will exonerate Kyle. Liquid City, I missed this earlier. Sorry. Says, question, any movement forward equals shot. What's the best way if you were in that situation to get out of the situation without being shot? Hands straight up. But after you've come onto someone's porch and thrown them and threatened to kill them, you might just be dead. Not that you should be, not that like you somehow deserve it, but you did all of the things that lead to justification. Try raising your hands. Whoa. Sorry. Crouch down, crumple to the ground, fall straight down. Any of those things shows submission, I suppose. But the most important thing is do not walk up onto someone's porch while they've had a gun and told you to leave. Don't do that. It's the other crazy thing. Bronca says it basically several times prior to that, he could shoot him justifiably. prior to the throw. Don't do that. Call Me Straw says Bronca expects UI with that kind of reflex response. Our brains aren't that fast. Also, how is Chad supposed to defuse the situation if you surrender with no option for stepping away from Kyle? I do think that's wrong, personally. I think if he turns away and walks, and Kyle shoots him in the back, that he's going to get a murder charge. Quartz 0235 says, I just looked at Jennifer's civil lawsuit against Kyle. Why doesn't she have wrongful death in the cause of action? Oh, is it public? I'm gonna be looking at that very soon. Rebecca Caliani, thank you for the donation. Eddie Alla read that one. Peter Quincy Taggart says, my go-to easy prime rib recipe is put on rub, sear in pan till outside is brown, cook in a 250-degree oven for 3.5 to 4 hours or desired internal temperature, just like restaurant. Charles Vance says, please analyze Amy's analysis for us. Not tonight, but maybe tomorrow. We'll see. Dorby says, throwing a Texan off his own porch while grabbing for his gun is asking to be shot. Both these dads were fools, but if stupidity was a crime in Texas, half the state would be locked up. Chain Breaking Sage says, you're speaking the truth, sir. 3 warnings max. Dorby says, let's not get distracted from the fact that the mom is still withholding POS. Hope telling your kid that stepdad killed his dad haunts her for life. Mike Hunt says, don't get married or have kids. This streams the lesson. Eddie Oliver says, thank you. I feel like I'm taking crazy pills because everyone cannot connect the physical assault as burglary here. Davy Crockett, Travis, and Bowie rock. Yeah, buddy. David Hunt says, settle a food argument, please. Is medium rare acceptable for burgers? Yes, of course it is. As long as you have good quality meat, medium rare is acceptable for burgers. If you don't know where the meat's coming from, you probably want to cook it to at least medium. But if it's good quality meat, medium rare is not only acceptable for burgers, it is delicious for burgers. Geomancy Games says, battling cancer, disabled, listen to you to help me sleep. Your backstory at the 30-minute mark is the most incredible story I've ever heard while high. That must have been Melinda at that point. Dr. Sammy D says, as a supporter of assisted suicide, I find it unconscionable that Chad Reed's doctor, Kyle Carruth, would ever be prosecuted for relieving his patients' violent suffering. Michael DeFore says, when World War III happens, we're going to need Texans. Aaron Pipe says, one of my relatives in the 1800s was reportedly lynched. He was part of the Sam Bass, or Bass, and he made the mistake of getting caught with cattle or horses he did not own. Yep. Can't do it. Chain Breaking Sage says, I'm from Oatmeal, Texas, and that's how we roll. Jack Hudler says, in Texas, if you live in a rural area where your nearest neighbor is a mile away, then it's just cap the perp and get the backhoe. Chris Onion says, important theology question. Those Christians who don't believe in birth control or jacking off, do they bang while pregnant? Seems just as wasteful to me. You're not going to make her more pregnant. Good question. You got to go to your second wife for that one. Andrea Moreno, message retracted. Thank you. Thank you. Jason the Great Awakening says, as a scientist myself, I highly object to calling the Luciferian cannibal Fauci a scientist. P-Dog Knight says, was also a college cheerleader. Best decision ever by a decent-looking, athletic, heterosexual, college-age male ever. Don't knock it till you try it, guys. The Squid says, does Melinda at least have luscious enough mommy milkers to be that crazy? No. Tranquilo says, you're going to talk about the Ghislaine Epstein trial at all? My man Joe Neerman, Good Logic, is talking about it more. He's there at the trial taking notes. Infamous one says, you think Christians don't have sex for pleasure too? No, he's saying to the Christians who profess that they don't. There are some people who say that sex is only for procreation, right? I don't think he was putting forward that argument. I'm certainly not. I'm not an idea that's or not a person that thinks that sex is only for procreation or anything like that. But I think there are people out there, and he was asking, what do they do? Call Me Straw says, God help us, Nick. Let Carl of Swindon stay in whatever dinosaur pit his wife's eggs scrambled in next to the corpse of UKIP. I'm begging you. I like Sargon. You don't have to. Texas P12 says, the debt laws are nice in Texas too. Raymond C says, Nick, so you're telling me if I can shoot 1 mile out, I can delete someone who's stealing from my property from Texas? Under existing case law, don't do it though. But under existing case law, that's the rule. That case is decided in 1921. Andrew Clark says, can judges run non-legal OnlyFans accounts? Yes, I think they can, so long as they are not violating their judicial ethics by disclosing anything they're not allowed to disclose, offering opinions on present cases, and as long as they would not be at risk of litigating a case involving their OnlyFans in their jurisdiction, which could be a problem. 2D Knight says, you're wrong. Best album is Kansas Left Overture. Tyler J. Ventura says, no sweet tea here in Commie Canada. I have my cousins in Tennessee bring me up 20 jugs of Peak every year. Frozen Toy says, kitchenware and candy bars. Rebecca Kalyani says, live trials are always interesting. A good preview generates interest. Wheelchair case is so sad. I don't see self-defense for Kyle. Agree with Andrew Branca. And again, I think Branca's position, though I disagree with it, is a reasonable position to have. I think he's got some errors in his reasoning that I think. That doesn't mean they're errors. It's just my perception. So I don't have any problem with anybody's position on the case. I can just give mine. And I'm not here to convince anybody. Really Now says, Nick realizing that his chat likes Nickelback. Pissed Off Patriot says, come on, Nick, sing a song in Richard's voice. What song would I sing in Richard's voice? Callan Shaw Indie Games says, I'm a new sub, but I like anyone who streams late, so thank you. Looking forward to future Scotch recommendations. Visitor says, we need to fix the adoption laws if we get rid of abortion. Yes, we do. Yes, we do. With arms wide open. Sing me a song, you're the piano man. Sing us a song tonight, because we're all in the mood for a melody, and your honors got us feeling all right. I'm Flag says, my first concert ever was 9 Inch Nails at Roy Wilkins in September 94. Nice. And now Nick and Kermit has destroyed that. What legal recourse do I have? You don't. You don't. JT Mish says, Roy Wilkins was a good venue, by the way. It's like all floor. All floor. JT Mish says, I understand that the U.S. is far less secular than the UK, but what exactly is the argument against legal abortion? It's necessary, even if morally ambiguous. I don't know that there's an argument against legal abortion. The question is, should abortion be protected as an unassailable right under the Constitution? That's the question the Supreme Court answers. After that, if the answer is no, it should not be protected, then it's just up to the states. Abortion is legal until they pass a law that says it's not. Radio Ruin says everyone should be subject to sodomy laws. Siren Zero says, no trolling, serious question. When does a zygote constitute a human life? Egg and sperm, 32 cell divisions, the embryo stage, fetal heartbeat. I personally just say, I say implantation because there are lots of cases of conception that are naturally sloughed off by the body, and that's less likely at implantation. But I think it's a distinction without a difference ultimately. Aaron Pipe says Roe should have relied on the 9th Amendment. It kind of does. Abortion was historically legal in the 1700s in the U.S. under common law, only illegal starting in the 1820s. Abortificants were legal in the 1700s. Abortificants are different than abortions, and that's part of the question that I think needs to happen. Abortificants have been legal basically forever. Jason the Great Awakening says, when these sickos stop profiting from genocide, maybe I'll have something to talk about with them. Not applicable says, life in the womb has been life as soon as it's detectable in the West since the BCs. Only recently has this financial incentive to abort changed this. Nathan D says, craziest thing is the idea that returning the abortion question to the states removes a woman's right to choose. It's like they think women can't vote. Kimberly Campbell says, Margaret Sanger, the founder of Planned Parenthood, wanted to eradicate black babies. People who research Planned Parenthood, they would see the majority of their businesses are in black communities. Jason Great Awakening says, strong justification, try industrialized genocide. Chainsaw Octopus says, logical consistency, it's hard. Jason Great Awakening says, that thing on your leg is called a foot. It's normal. He also says, is this change in dislike policy meant to make it look like Brandon didn't poop himself and Ethan Ralph isn't fat? Why? It's for big corporations, news media, and Biden. I mean, that's all it is. Those are the people getting dislike bombed. Nobody else is. Dabber Wolf says, hey, Nick, watch Stone Ocean anime. Binger's in it. Donald J. Trump says, Legal Bites has given me chubbies. Dabber Wolf says, wow, Nick, ending your stream early tonight, I see. Also, could you have Sydney on your channel? Sydney Watson? Yes. I've got a backlog of people. I got to talk to Styx. I was going to have on a while back. Gothic X, Eric July. These are the Razor Fist, Carl Jobs, a bunch of people that I have on the list that I want to have back on, but I just haven't gotten around to it. The Under Armour Gamer says, I'm late. Thoughts on Trump on the flight logs, and it's my birthday today. I have no opinion on the flight logs. If people are flying to Lolita Island or whatever to bang underage kids for Jeffrey Epstein, then they all deserve the wall. I don't care who's on it. But the question is, produce the flight logs. And where'd they go? What'd they do there? That's the trick. But I don't know. I'm not following that trial because I'm following Kim Potter. Harry Bolognese says, shout out to Hubert Cumberdale. Hashtag smoke weed every day. Nick's Heck says the song Core is Where the River Goes. Oh yeah, that's a good song. Good song. All right, guys. That's it. I got to end this stream. Catch you guys soon. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, to make the law what we have now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than me.